Next page. Chapter 4: The legal position of the insolvent. 4.1 Contracting. The Insolvency Act does not generally remove the insolvent's contractual capacity. Mackay v. Fay-No 2006, 3, SA 182, SCA. However, certain restrictions exist to protect creditors, S23-2. 4.1.1 Prohibited contracts. The insolvent may not dispose of any estate property, S23-2. The insolvent may not contract without the trustee's consent, if the contract could negatively affect the estate or any contribution he must make, S23-5. Contributions become due only after the master declares that the insolvent's income is not needed for his support. In Mervis Brothers, Proprietary, Limited v. Harnacorn 1963, 2, SA 125 T. The insolvent, H, gave an undertaking to pay a debt incurred before sequestration. The trustee did not consent, but since the master had not assessed a contribution, the undertaking was binding. If a contract with an insolvent is claimed to be invalid, the alleging party must prove the facts. Cowan v. Toffee 1947, 2, SA 1148, T. 4.1.2 Effect of a contract which is not prohibited. Valid and binding if the trustee's consent is not required or is obtained, S23-2. However, the insolvent cannot enforce performance unless the Insolvency Act or another law explicitly allows it. DePolo and Another v. Dreyer, and Others 1991, 2, SA 164, W. Example: the insolvent cannot demand money from a post-sequestration partnership unless the law grants him that right. But he can claim payment for work done post-sequestration, S23-9. Contractual rights the insolvent can enforce are listed in S23-7, 9. 4.1.3 Effect of a prohibited contract. A contract disposing of estate property is voidable, not void, at the trustee's discretion. W. L. Carroll and Co. v. Ray Hall Motors, Proprietary, Limited 1972, 4, SA 728, T. If the trustee does not set it aside, it remains binding. Ex parte Olivier 1948, 2, SA 545, C. The insolvent cannot sue for performance unless explicitly allowed by law. The Polo case. If the trustee voids the contract, he can recover the insolvent's performance but must restore benefits received by the other party. Estate Law v. Credit Corporation of SA Limited 1956, 3, SA 303, C. Section 24(1) protects bona fide third parties who unknowingly contract with an insolvent. Applies only to new assets acquired after sequestration, not substitutes for existing estate property. Wessels v. de Klerk and Another 1960, 4, SA 310 T. The third party must prove complete lack of knowledge of the insolvency. Fay-No and Another v. Mackay, 2004, 4 or SA 50, C. 54. 4.2 Earning a livelihood. The insolvent is allowed to work and make necessary contracts, S23-3, but he cannot trade as a general dealer or manufacturer without the trustee's consent. The trustee's consent decision is independent and not subject to creditor instructions. A J. Ferreira Beleggings, Edens, BPK v. SWAT 1969, 2, SA 170, E. Definitions under S2. Trader broadly includes businesses involving sales, exchanges, manufacturing, or construction. General dealer trades in various goods at a fixed location. S.B. van der Merwe 1980, 3, SA 406, North Carolina. Manufacturer operates a factory. A J. Ferreira Beleggings case. Court interpretations. A milk depot is not a general dealer. Ex parte Duplessis 1957, 2, SA 253 W. A restaurant is not a general dealer. Avi Papangelis 1960, 2, SA 309, O. Effect of consent and violations. Consent to trade does not entitle the insolvent to receive unrelated income, for example, donations. Cilliers and Others v. Liebenberg, and Others, 1909, 26 SC 611. Contracts incidental to the business are allowed. Johannesburg Municipality v. Davis 1925 AD 395. Any surplus income may be claimed by the trustee for the estate, Rudolph v. the Master and another 1927 TPD 96. Unlawful trade, without consent, is a criminal offense, S 137C. Example, ignorance is not a defense, Avi Kassim 1932 CPD 209. Contracts made in violation of this rule are voidable, ex parte Olivier 1948, 2, SA 545, C. Appeal process. The insolvent or creditors may appeal the trustee's consent/refusal decision to the master, whose decision is final, S 23.3. A copy of any consent granted must be sent to the master, S 23.3 bis. This summary captures the key points while preserving the legal principles, case law, and statutory references. Let me know if you need further refinements. Next page. Instituting and defending legal proceedings in insolvency. 4.3.1 Proceedings which may be brought/defended personally by insolvent. Insolvency does not necessarily prevent an individual from being a party to legal proceedings. Revler v. Lansdowne NN Ander NN, 1991, 3, SA 175, T. 177. Under S 23.6, 10, an insolvent may sue or be sued in his own name without reference to the trustee in cases involving status-related matters, for example, divorce. Rights that do not affect the insolvent estate, such as right to receive maintenance, Weinberg v. Weinberg 1958, 2, SA 618, c. Protection against unlawful dispossession of property, Murray v. Engler Earthworks, Proprietary, Limited, Engler Earthworks, Proprietary, Limited v. Murray 1998, 2, SA 450, E. 454. Claims for remuneration or professional services rendered after sequestration. Pension entitlements for prior services. Claims for compensation due to defamation or personal injury, detailed in Chapter 5. Delictual claims for wrongs committed after sequestration. Despite the loss of control over his estate, an insolvent retains a reversionary interest in it, meaning he may litigate to ensure proper administration. Cooper v. Stern and Hewitt No. 1941 WLD 13-4, Swart v. Starbuck and others 2016, 5, SA 372, SCA 377. Recover or protect vested property if the trustee refuses to act. Mears v. Rissick, Mackenzie No. and Mears Trustee 1905 TS 303. Nevote v. the Master and others NNO 1988, 4. SA 513, A 524-530, Vauger and others v. Clayhans 2003, 2, SA 148, C. 153-4, Hockly Soft Copy v. Brewers Marketing Intelligence, Proprietary, Limited and others 2005, 1, SA 398, C. 424-5, National Director of Public Prosecutions v. Ramlachman 2017, 1 Saka 343, SCA 348-9, Mulawuzi v. Old Mutual Assurance Company, South Africa, Limited and others 2017, 6, SA 90, SCA 98-9, Penguin. Apply for an interdict preventing the trustee from realizing further assets if enough funds have been raised. Jacobs v. Hessels, 1984, 3 SA 601, T. Sue the trustee for maladministration-related damages, Eka v. Dean 1940 AD 206. Insolvent cannot interfere with administration unless he suffers injustice due to irregularity or bad faith. Jordan v. Richter N. Ander 1981, 1, SA 490, 0. Example, if an asset is sold below its real value, this alone does not invalidate the sale unless irregularities or bad faith exist. Kruger v. Symington No. N. Ander 1958, 2, SA 128, O. Malavida Wet No and others 1999, 2, SA 1024, W. 4.3, 2 Security for costs. Magistrates Court. An insolvent must provide security for costs upon the defendant's request. Rule 62(1)b, Magistrates Court's rules. Failure to provide security may result in dismissal of the action. High Court, different rules apply. If the Insolvency Act expressly allows the insolvent to sue, for example, claims for remuneration, security is not required unless the claim is clearly vexatious. Argus Printing and Publishing Company, Limited v. Anastasiades 1954, 1, SA 72, W. 79, Hobson No v. Abid 1981, 1, SA 556, N. If the action is unrelated to the Insolvency Act, for example, general administration matters, the court may require security if it deems the action reckless or vexatious. Eka v. Dean 1940 AD 206, Director, Law Society of Cape of Good Hope v. Budricks, 2002 or SA 541, SE 544-5, Mountain Service Provider, Proprietary, Limited v. Afrocall, Proprietary, Limited 2007, 6, SA 620, SCA 625. Factors considered. Prospects of success of the action. Whether trustee or creditors could have brought the action. Previous litigation history. Israel v. Berger 1961, 1, S. 827, 04.3.3 Entitlement to costs. When the insolvent litigates personally and wins costs. Costs award belongs to the insolvent personally, and he may use it as he sees fit. Schumann v. Thompson 1927, WLD 298. Damages for trustee maladministration accrue to the estate, but cost awards against the trustee benefit the insolvent. Eka v. Dean 1940 AD 206. If there is a shortfall in costs recovered from the trustee, the deficiency is deducted from the damages paid to the estate. Next page. Holding office as an unrehabilitated insolvent. General disqualifications. An unrehabilitated insolvent is disqualified from holding numerous offices. Key restrictions include prohibitions on being a trustee in an insolvent estate, S55A Insolvency Act, a liquidator of a company or close corporation, S372A, Companies Act 61 of 1973, SS 372 and 373, read with S66-1, Close Corporations Act 69 of 1984, and Schedule 5, Item 9, Companies Act 71 of 2008. A Business Rescue Practitioner, S138-1D, Companies Act 71 of 2008. Political and legislative restrictions. Cannot be a member of National Assembly, National Council of Provinces, Provincial Legislature, or Municipal Council, SS 47-1C, 62, 106-1C, and 158-1C, Constitution of RSA, 1996. National House of Traditional Leaders, S5C, National House of Traditional Leaders Act 22 of 2009. Corporate and business restrictions. Company Director. Disqualified unless granted an exemption by the court, S69 8BI and 11, Companies Act 71 of 2008. Past cases, Ex parte Harrod 1954, 4 SA 28, SR 30, Ex parte Dworsky 1970, 2, SA 293, T. Close Corporation Management. Prohibited unless authorized by the court, S47-1BI, Close Corporations Act 69 of 1984. Other corporate officers. Cannot be a director of a cooperative, S33-2B, Cooperatives Act 14 of 2005. Cannot be a director of a mutual bank, S38B, I Mutual Banks Act 124 of 1993. Cannot register as a credit provider, debt counselor, or payment distribution agent, S46-2, National Credit Act 34 of 2005. Cannot be a board member of the Land and Agricultural Development Bank of South Africa, SS1 and 10E, Land and Agricultural Development Bank Act 15 of 2002. Legal profession restrictions. Legal Practice Council and legal profession bodies cannot be a member of the Legal Practice Council, SSA 2A and 11, Legal Practice Act 28 of 2014, cannot serve on the Legal Practitioners Fidelity Fund Board, S64-2, cannot be part of the National Forum on the Legal Profession, S99-2A, enrollment as a legal practitioner. Application must include a declaration regarding sequestration status, S95-1K and T. Read with SS24-2D, 31A and B3, Legal Practice Act. Trust accounts. If handling trust money, further restrictions apply if the legal practitioner becomes insolvent, S84, Legal Practice Act. The High Court may appoint a curator bonus to manage the trust account, S91B. Property and financial professions. Property practitioner. Immediately disqualified from holding a Fidelity Fund certificate, S59-1A, B, Property Practitioners Act 22 of 2019, must comply with administrative requirements within 30 days, S59-1I-7. Liquor industry. Cannot be a registered manufacturer or distributor of liquor, S11-2B, Liquor Act 59 of 2003. Trustee of the estate may continue the business or propose a transfer of registration, S17-1 and 2. Sheriffs and debt collection. Cannot be a sheriff, SS31A and 33-1C, Sheriffs Act 90 of 1986. Cannot register as a debt collector, S10-1V, Debt Collectors Act 114 of 1998. Other business activities. Cannot be a dealer in second-hand goods, pawnbroker, or scrap metal dealer, S1 dealer and S14-1C, Second-Hand Goods Act 6 of 2009. Executorship, trusteeship, and guardianship. Deceased estates. Sequestration does not automatically terminate an insolvent's office as executor, unless they fail to provide security, S23, Administration of Estates Act 66 of 1965, Trustees of Right v. Executors of Right, 1872, 2 Roscoe 84. Tutorship/curatorship. Can retain office unless security is not provided, S77-3, Administration of Estates Act. Cases, De Villiers, Tutor v. Stuckeris, 1829, 1 Men's 377. Trusteeship in a trust. The Master of the High Court may remove the insolvent from office, S22C, Trust Property Control Act 57 of 1988. The trust deed may also automatically terminate trusteeship. Case, Sinclair v. Meinke, 1874, 4 Book 40. Miscellaneous restrictions. Membership in statutory bodies. Cannot serve on 133 statutory councils, boards, or bodies, Rostov, 2018, 81 THR 393 402. Constitutional considerations. Right to freedom of trade and profession. Section 22 of the Constitution, every citizen has the right to choose their trade, occupation, or profession freely. However, the practice of a trade, occupation, or profession may be regulated by law. Potential constitutional challenge. If challenged, the justification under Section 36 of the Constitution would likely be public protection against untrustworthy insolvents. Comparative legal systems could offer a less prejudicial approach. Rostov, 2018, 81 THR HR 403 FF. Next. Always remember to maintain the numbering as posted. Page 4.4 Holding office. An unrehabilitated insolvent is disqualified from holding numerous positions. Key disqualifications include 1. Legal and corporate restrictions. Cannot be appointed as a trustee in an insolvent estate, S55A, Insolvency Act, and must vacate office if already a trustee when sequestrated, S58A. Disqualified from being a liquidator of a company or close corporation, S372A, Companies Act 61 of 1973, SS 372 and 373, 1973 Act, read with S66(1), Close Corporations Act 69 of 1984, and Schedule 5, Item 9, Companies Act 71 of 2008, cannot be a business rescue practitioner, S138 1D, Companies Act 71 of 2008. 2. Political and government positions. Ineligible to be a member of the National Assembly, National Council of Provinces, Provincial Legislature, or Municipal Council, SS 47 1C, 62, 106 1C, 158 1C, Constitution of the Republic of South Africa, 1996. Disqualified from membership in the National House of Traditional Leaders, S5C, National House of Traditional Leaders Act 22 of 2009. 3. Business and professional disqualifications. Cannot be a company director unless exempted by the court, S69 8BI and 11, Companies Act 71 of 2008. Under the 1973 Companies Act, courts allowed an unrehabilitated insolvent to become a director if no risk to private interests or the public existed, ex parte Harrod 1954, 4, SA 28, SR 30, ex parte Dworsky 1970, 2, SA 293, T. May not manage a close corporation without court approval, S47 1BI, Close Corporations Act 69 of 1984. Cannot be a director of a cooperative, S33 2B, Cooperatives Act 14 of 2005. Disqualified from being a director of a mutual bank, S38B, I, Mutual Banks Act 100 and 24 of 1993. Cannot register as a credit provider, debt counselor, or payment distribution agent, S46-2, National Credit Act 34 of 2005. 4. Legal profession and related fields. Cannot be a member of the Legal Practice Council, SS 82A and 11, Legal Practice Act 28 of 2014. Disqualified from serving on the Legal Practitioners Fidelity Fund Board, S64-2, and the National Forum on the Legal Profession, S99-2A. In a legal practitioner's enrollment application, must declare sequestration status, S95-1K and T. Read with SS 24-2D, 31A and B3, Legal Practice Act. If handling trust monies, additional rules apply, including potential appointment of a curator bonus, S91B, S84-1, Legal Practice Act. 5. Property and financial sectors. Disqualified from holding a Fidelity Fund certificate as a property practitioner, S59-1A, B, Property Practitioners Act 22 of 2019. Must take corrective steps within 30 days, S59-1I, 7. Cannot be a registered manufacturer or distributor of liquor, S11-2B, Liquor Act 59 of 2003. Cannot act as a sheriff due to ineligibility for a Fidelity Fund certificate, SS 31A and 33-1C, Sheriff's Act 90 of 1986. Cannot register as a debt collector, S10-1A, Debt Collectors Act 114 of 1998. Disqualified from being a dealer in second-hand goods, pawnbroker, or scrap metal dealer, SS1 dealer and 14-1C, Second-Hand Goods Act 6 of 2009. 6. Executors, curators, and trusteeships. Sequestration does not automatically remove an insolvent, as an executor of a deceased estate if duties can still be performed. S23, Administration of Estates Act 66 of 1965, Trustees of Right v. Executors of Right, 1872, to Roscoe 84. Similarly, it does not terminate tutorship or curatorship unless security is not lodged with the master, S77-3, Administration of Estates Act, De Villiers, Tutor v. Stuckeris, 1829, 1 Mens 377. The master may remove an insolvent from trusteeship of a trust, S22C, Trust Property Control Act 57 of 1988, Sinclair v. Meinke, 1874, 4 Boot 40. If the trust deed provides for automatic termination, trusteeship ends upon sequestration. 7. Statutory bodies and constitutional considerations. An insolvent may not be a member of 133 statutory councils, boards, or bodies. Rolstoff, 2018, 81 THR, Char 393 402. Restrictions must be balanced against the constitutional right to freedom of trade, occupation, and profession. S22, Constitution of the Republic of South Africa, 1996. Justification under S36, Protection of the public from untrustworthy individuals. Comparative legal approaches may offer softer alternatives. Rolstoff, 2018, 81 THR 403 FF. Next page. Chapter 5, Vesting of the assets of the insolvent. 5.1 Vesting of estate in trustee. Trustee's role: collect, realize and distribute estate assets among creditors as per the Act. Vesting process. Sequestration order, including provisional, divests insolvent of the estate. Estate vests first in the master, then in the trustee. S21A. Vesting applies even to property sold in execution, but not yet transferred. Simpson v. Klein No. 1987, Cyphrex Bank Limited v. Sheriff 1997, Naidu v. Matlala No. 2012. Trustee litigates on behalf of estate, not insolvent. Mulawudzi v. Old Mutual 2017. Trustee has no beneficial interest in estate property. Thorn v. Receiver of Revenue 1976. If a provisional trustee is appointed, estate vests in him first. S54-5. Estate remains vested until court discharges sequestration order. Muhammad v. Lockhart 1944. Creditors accept a composition offer restoring property to insolvent. Insolvent is rehabilitated under S100 and 24-3. If trustee resigns, is removed, or dies, estate revests in master until a new trustee is appointed. S25-2. 5.2 Property which falls into estate. Insolvent estate includes all property at sequestration date, including under sheriff's attachment. Property acquired during sequestration. S22, Vauger v. Clayhans 2003. Definition of property. Movable and immovable property in South Africa includes contingent interests, except fidei-commissary heirs/legatee. Movable property, any right or interest that is not immovable. Types of property vesting in trustee. Foreign assets, if domiciled in SA jurisdiction at sequestration time. Solvent spouse's property. Insolvent's title deeds, books of account, money. Proceeds of execution sale held by an officer. Business goodwill, intellectual property, debts owed to insolvent. Shares, inherited property, property acquired during sequestration. Claims for trustees' maladministration. Bertelsmann et al., Mars, The Law of Insolvency, 2019. Foreign property. Exception: movable foreign property owned at sequestration, if domiciled in SA. Trustee needs foreign court recognition to administer assets. Herman No v. Ted 1929. Judgments affecting property ownership. Sale and execution post-sequestration is void unless buyer acted in good faith. S70 Magistrates Courts Act 1994. Sheriff must stay execution if sequestration occurs. Husserman v. Absa Bank 2020. Immovable property sold but not transferred still vests in estate. Forey v. Edkins 2013. Husserman v. Absa 2020. Court may order property transfer in limited cases. S21C. Sectional titles and insolvency. Trustee takes over ownership of units in insolvent's name. Harris v. Trustee of Buisson 1840. Transfer restrictions by homeowners associations enforceable against trustees. Willow Waters HOA v. Coker No 2015. Trustees can resist insolvent's unlawful occupation claims under PI Act. Bota No v. Keys 2014. Presumptions regarding ownership. If insolvent possesses property, assumed to belong to estate. S24-2. If post-sequestration creditor claims an asset, assumed not to belong to estate unless proven otherwise. Marital property in sequestration. Marriage in community of property. Both spouses are deemed insolvent. Joint and separate assets vest in trustee. Duplessis v. Pina No 2003, Wenzel v. Discovery Life 2021. Spouse's inheritance vests in estate despite contrary will provisions. Badenhorst v. Becker No 1994. Marriage out of community. Solvent spouse's property vests in trustee until released. S21. Discussed in Chapter 6. Divorce and asset transfer. Half share of property vests in ex-spouse only upon registration in deeds registry. Fisher v. Ubami Ashishi Trading 2019. Intellectual property and electronic data. Computer files on a third party's device may be searched. LaRue v. Viana No 2008. Electronic data included in estate, bank accounts and insolvency. Insolvent's bank credit balance is estate property. Herigel No v. Bond Rhodes 1980. Illegally obtained funds do not vest in estate. Nissan S.A.V. Marnitz No 2005. Fraud victims cannot claim against fraudster's estate, only delictual claims. Duma Case 2013. Distinction between Nissan and Duma. In Nissan, funds were mistakenly transferred and wrongfully withdrawn. In Duma, fraudster controlled deposits, making the investment transaction the cause of payment. Confirmed in S.A. Reserve Bank v. Lebanon No 2021. Next page. 5.3 Property which does not fall into estate. 5.3.1 Wearing apparel, bedding, etc. Insolvent may retain personal wearing apparel, bedding, and essential household furniture, tools, and means of subsistence as determined by creditors. S.8026. Insolvent can renounce statutory protection of these assets in favor of creditors. Ex parte Anthony N. Ander and Cess like Ansoic 2004, SA 116, c. 125. However, renunciation disapproved by other courts as protection benefits debtors, families, and public, and cannot be waived. Ex parte Cross and another 2015, 1, SA 405, NWM. Ex parte Van Dyke 2015, JDR 0667, GP, Paris 19-20. 5.3. 2 Remuneration for work done. Insolvent retains remuneration for work done or professional services rendered post-sequestration, S23-9. However, trustee may claim portion of income deemed unnecessary for support by the master, S23-5, Ex parte Van Rainsburg 1946, OPD 6470, Miller v. Janks 1944 TPD 100, and 27-130. Master's decision on surplus income is quasi-judicial/administrative and reviewable under S. 151, Ex parte Theron N. Ander, Ex parte Smith, Ex parte Webster 1999, 4, SA 136, 139. Insolvent must record earnings and furnish records to trustee on demand. Trustee can claim surplus income from insolvent's employer, S23-5. Trustee may recover surplus by writ of execution upon master's certificate, S23-11. No time limit for trustee to claim surplus income, but insolvent may seek court order declaring property, his own before/at rehabilitation, Panamo No v. Taylor No, and another 1963, 2, SA 656, N. 661-2. Unlawful income is not excluded from insolvent estate, Singer No v. Vice and another 1992, 4. SA 362, T. 5.3.3 Pension. Insolvent retains pension for services rendered, S23-7. Some statutes exclude pensions from the estate, scope depends on legislative intent. Exclusion of only post-sequestration payments. General Pensions Act 29 of 1979, Foyt v. First Rand Bank BPK 2002, 5, SA 149, T. Pension Funds Act 24 of 1956, M and another v. Marino and others 2026, SA 55, SCA 6167. Broader exclusion of both payable and received benefits. Government Employees Pension Law, 1996, S23. 5.3.4 Compensation for defamation or personal injury. Insolvent may retain compensation for defamation or personal injury suffered pre- or post-sequestration. S23-8, Fairley v. Raubenheimer 1935 AD 135 143. Personal injury includes bodily injury and inuria, injury to personality interests. De Wetnil v. Jurgens 1973, SA 38, A. Compensation may include general damages, for example, pain and suffering, loss of amenities. Special damages, for example, medical expenses, loss of earnings. Santum versicarans mascapi, BPK v. Kruger 1978, 3, SA 656, A. Pre-Santum Case Law Limited recoverable defamation damages to injury to reputation, with business-related losses vesting in the trustee. Argus Printing and Publishing Company, Limited v. Anastasiades 1954, 1, SA 72, W. After Santum, distinction appears invalid, allowing insolvent to retain full defamation compensation. If compensation is awarded before sequestration, it remains separate property. Santum Limited v. Norman 1996, 3, SA 502, C. Insolvent requires court's leave to sue trustee for malicious prosecution or defamation. S23-8 Proviso. 5.3.5 Compensation for occupational injuries or diseases. Compensation under the Compensation for Occupational Injuries and Diseases Act 130 of 1993 is excluded from the estate. Exclusion justified as compensation for personal injury or due to S32(1)(b, which prohibits attachment or execution. 5.3.6 Benefits payable to minor. Benefits or gratuities paid to a minor do not form part of the insolvent estate. S131 1 of the Occupational Diseases in Mines and Works Act 78 of 1973. 5.3 7 Unemployment insurance benefits. Benefits under the Unemployment Insurance Act 63 of 2001 are generally non-assignable and non-attachable, except for maintenance orders. S33. Uncertainty exists as to whether these benefits vest in the insolvent estate. Next page. 5.3 Property which does not fall into the estate. 5.3.1 Wearing apparel, bedding, etc., insolvent may retain. Wearing apparel and bedding, household furniture, tools, and means of subsistence, as determined by creditors. S82-6. Insolvent may renounce protection, but this has been disapproved. Ex parte Anthony N. Ander and Ses Sorgalike Ansowek 2004, SA 116, C. 125. Insolvent may renounce protection in favor of creditors. Ex parte Cross and another 2015, 1, SA 405, NWM, protection benefits debtors, families, and the public, and cannot be waived. Ex parte Van Dyke 2015 JD, R0667, GP, Paris 19-20, followed Cross ruling. 5.3, 2 Remuneration for work done. Insolvent may retain earnings for work done after sequestration. S23-9. Trustee entitled to amounts not necessary for insolvent and dependents. S23-5. Combined effect. Earnings remain with the insolvent until master determines a portion as unnecessary. Ex parte Van Rensburg 1946 OPD 6470. Only upon master's decision does the trustee claim a portion. Miller v. Janks 1944 TPD 100 and 27 130. Master's decision is quasi-judicial and reviewable under S 151. Ex parte Theron N. Ander, Ex parte Smith, Ex parte Webster 1999, 4, SA 136, 139. Insolvent must record earnings and provide records to the trustee. C 14.6. Trustee can claim surplus wages by notifying employer. S23-5. Recover funds via writ of execution upon master's certification. S23-11. No time limit for trustee to claim surplus income before rehabilitation. Insolvent can seek court order declaring property as their own, Panamo No v. Taylor No, and another 1963, 2, SA 656, N. 661-2. Unlawful income is not protected. Singer No v. Vice and another 1992, 4, SA 362, T. 5.3.3 Pension. Insolvent may retain pension benefits for services rendered, S. 23-7. Some statutes exclude pensions from the insolvent estate. General Pensions Act 29 of 1979 S3, Fort v. First Rand Bank BPK 2002, 5, SA 149 T. Pension Funds Act 24 of 1956, S37B, M and another v. Marino and others 2020, 6, SA 55, SCA, 61, 67. Government Employees Pension Law, 1996 S23, provides broader protection. 5.3.4 Compensation for defamation or personal injury. Insolvent retains compensation for defamation or personal injury, S23-8. Fairley v. Raubenheimer 1935 AD 135-143, covers bodily and personality injuries. DeWitt No v. Jurgens 1970, 3, SA 38, A includes insult, contumelia, and loss of consortium. Santam Versicaransmascapi BPK v. Kruger 1978, 3, SA 656, A, covers general and special damages. Previously, business loss claims vested in trustee, Argus Printing and Publishing Company Limited v. Anastasiades 1954, 1 SA 72, W, but distinction invalid after Santam case. If compensation is awarded before sequestration, it remains separate property. Santam Limited v. Norman 1996, 3, SA 502, C. Insolvent needs court leave to sue trustee for malicious prosecution or defamation. 5.3.5 Compensation for occupational injuries or diseases. Compensation under the Compensation for Occupational Injuries and Diseases Act 130 of 1993 is excluded from the estate. Section 32(1)b states that compensation cannot be attached or executed by court order. 5.3.6 Benefits payable to minor. Occupational Diseases in Mines and Works Act 78 of 1973, S. 100, and 31(1), a minor's benefits or gratuity do not form part of the estate. 5.3. Term Unemployment Insurance Benefits. Unemployment Insurance Act 63 of 2001 S. 33, benefits are not assignable or attachable, except for maintenance claims. Uncertainty whether benefits vest in insolvent estate. 5.3.8 Insurance Policies. I. Policies covering liability to third parties. If insured before sequestration, third-party claims against the insurer pass to the third party, S. 156. Third party can claim directly from the insurer. Gypsum Industries Limited v. Standard General Insurance Company, Limited 1991, 1, SA 718, W. Key aspects of S. 156. Covers liability insurance, including cases where another person insured the insolvent. Unitrans Freight, Proprietary, Limited v. Santam Limited 2004, 6, SA 21, SCA, 26. Limited to Indemnity Insurance, Benfin Investments, Proprietary, Limited v. KZN Resins, Proprietary, Limited TA KZN Resins, 2011, for all SA 369, SCA, 383-4, does not grant third parties greater rights than the insured had. Kutsia v. Attorneys Insurance Indemnity Fund 2003, 1, SA 1, SCA, 8. Insurer can defend claims based on policy exclusions. Supermarket Harsensbach, Proprietary, Limited v. Santam Insurance Limited 1989, 2, SA 790, W. 794. Applies to companies in liquidation. Van Rienon v. Santam Limited 2013, 5, SA 595, SCA, 599. No statutory session, creates a new cause of action for third parties, Van Reenen v. Santam Limited 2013, 5, SA 595, SCA, 599-601. Claim prescribes 3 years from sequestration or winding up. 2. Life policies. Long-Term Insurance Act 52 of 1998, S63(1) protects life, disability, health, or assistance policy benefits in force for 3+ years. Assets acquired solely with such benefits within 5 years, S63(2). Full policy value now protected, S63(2), amended the 28th of February 2014. Protection lost if policy was taken out to defraud creditors, S63(4). If policy benefits are payable to a third party, they never vest in the insolvent estate, Petersa v. Shrewsbury-No and others, Shrewsbury-No v. Love and others 2005, 1, SA 309, SCA, 314. Trustee only has rights to the surrender value before death. Warwicker and another NNO v. Liberty Life Association of Africa Limited 2003, 6, SA 272, W. Insolvent bears onus to prove S63(1) protection, S63(3). Policy benefits cannot be attached during the insured's lifetime, S63(1)(I). Benefits not available for debt payment if the insured is survived by a spouse, child, stepchild, or parent, S63(1)(2). Next. Page 5.3.9 Share in accrual. Under the Matrimonial Property Act 88 of 1984, a spouse's right to share in the accrual of the other spouse's estate does not form part of the insolvent estate, S32. The accrual claim arises only upon dissolution of the marriage, S31. The exclusion applies during the subsistence of the marriage, S32. Underscore. The 5th of March 2010 Trust Property/Funds. General rule: money or property transferred to an agent for a mandate falls into the agent's insolvent estate. Trust property exceptions. Trust assets do not form part of the trustee's personal estate on insolvency, S12, Trust Property Control Act 57 of 1988. Legal practitioners' trust accounts are regulated by S84 and S90 of the Legal Practice Act 28 of 2014, effective the 1st of November 2018. S90, if a legal practitioner becomes insolvent, the High Court may appoint a curator bonus to control the trust account. S84 specifies obligations for handling trust monies. Property practitioners' trust accounts are excluded from their insolvent estate. S59(4), Property Practitioners Act 22 of 2019, effective the 1st of February 2022. Sheriff's trust accounts are protected from insolvency. S22(3), Sheriff's Act 90 of 1986. Financial institutions holding trust property do not include it in their estate. S45, Financial Institutions, Protection of Funds, Act 28 of 2001. Medical aid schemes. Trust funds are separate from other assets only if a trust relationship exists. Genesis Medical Aid Scheme v. Registrar, Medical Schemes and Another 2017, 6, SA1, CC, 17-19. Securities transactions that are effective against third parties are also effective against insolvency administrators. S46, Financial Markets Act 19 of 2012, effective the 3rd of June 2013. Defines securities, insolvency administrator, and insolvency proceedings under S1. Underscore. The 5th of March 2011 Right of labor tenant to land or right in land. Labor tenants' right to apply for land under the Land Reform, Labor Tenants, Act 3 of 1996, does not form part of the insolvent estate, S39C. Underscore. The 5th of March 2012 Friendly Society Monies and Assets. Benefits due under a friendly society, after 3 years of membership, do not form part of the insolvent estate, S48A1, Friendly Societies Act 25 of 1956. If pledged, only the excess over the secured liability is excluded, S48A2. Underscore. The 5th of March 2013 Property acquired with money from protected sources. Property bought with money from excluded sources does not vest in the trustee. Also applies to property acquired with remuneration from work done during insolvency. Ex parte Fowler 1937 TPD 353. An insolvent who lived frugally on his salary accumulated an estate. Court ruling, the property vested in him since the master did not declare a surplus above necessary support. _ 5.4 Disposal of estate property by insolvent. General rule, an insolvent cannot dispose of estate property. Exception, if a caveat on immovable property expires, a valid act of registration, transfer, mortgage, etc., can occur, S25(3) Insolvency Act. Key cases and principles. Caveat expiry does not revest property in the insolvent. If an insolvent unlawfully disposes of immovable property, trustee may recover compensation, S25(4). Claim possible against insolvent personally. Person acquiring the property knowing it was insolvent estate property. Person acquiring without knowledge, but without giving sufficient value. Compensation claim. Value of the property if acquired knowingly. Difference between property value and price paid, if acquired without sufficient value. Remedies for the trustee. Claim return of the property, if disposal invalid. Fano and another v. Mackay, 2004, 4 all SA 50, c. Mackay v. Fano and another 2006, 3, SA 182, SCA, 187. Claim compensation under S25(4). Exception, if the caveat had expired. Property return cannot be claimed. _ 5.5 Acquisition of new estate during insolvency. Insolvent may acquire new estate that does not vest in the trustee. New estate can also be sequestrated, see 1.3.1. Next page. Chapter 6, Vesting of the assets of the solvent spouse. 6.1 Vesting of assets in trustee. A sequestration order vests the insolvent's property in the master and later in the trustee. Section 21(1) also vests the solvent spouse's separate property in the master and trustee, treating it as part of the insolvent estate. Effect: the trustee temporarily becomes the owner of the solvent spouse's property, but must release qualifying assets under S21(2). Consequences: until release, the solvent spouse cannot dispose of or encumber the assets. Case law. De Villiers No v. Delta Cables, Proprietary, Limited 1992, 1, SA 9, A, 15-16, trustee acquires ownership of solvent spouse's property. Hoxon v. Lane No 1998, 1, SA 300, CC, 315, temporary nature of vesting upheld. Mutala and another NNO v. Moller and others 2014, 6, SA 223, GJ incorrect decision contradicting case law. Purpose of S21. Prevent collusion between spouses to conceal assets from creditors. Helps trustees determine ownership of assets in mixed estates. Constitutional challenge, Hoxon v. Lane No and others. Not expropriation, ownership transfer is temporary. Rational differentiation, solvent spouses are treated differently for legitimate reasons. No unfair discrimination. Does not affect a historically disadvantaged group. Serves an important societal function, protecting creditors. Does not impair the dignity of solvent spouses. 6.1.1 Meaning of solvent spouse. Extended definition includes spouses married under any law or custom, unmarried partners in opposite-sex relationships. Chaplain No v. Gregory, or Wild, 1950, 3, SA 555, c. Only legal spouses' property vests, not that of third parties. Same-sex couples. Covered under the Civil Union Act 17 of 2006. Civil unions are treated as marriages for legal purposes, S 13(1) and 2. Exclusions from S 21. If spouses are married in community of property, both estates are sequestrated, and S 21 does not apply. Badenhorst v. Becker No 1994, 2, SA 155, N. Duplessis v. Pina No 2003, 1, SA 671, SCA. If the relationship ended before sequestration, death, divorce, or separation, S21 does not apply. Janet v. Van den Heever NNO 2001, 1, SA 731, W. Shrewsbury v. Van Ruyen No 2004, 1, SA 226, SE. 6.1. 2. Duty of solvent spouse to lodge statement of affairs. Obligation. Upon receiving a sequestration order, the sheriff must serve it on the solvent spouse if she has a separate estate. Timeline. Solvent spouse must file a statement of affairs within 7 days, verified by affidavit, S16-3. Details required. See Chapter 2 on voluntary surrender. Assistance. The master may approve reasonable fees for help preparing the statement, S16-5. 6.1.3 Postponement of vesting. Hardship consideration. If immediate vesting would severely prejudice the solvent spouse, the court may postpone vesting, S2110. Grounds for postponement. The solvent spouse is a separate trader from the insolvent spouse. The solvent spouse faces serious prejudice from immediate vesting. Court's conditions. Postponement only granted if the spouse provides arrangements to safeguard the insolvent estate's interest. Arrangements must be completed immediately upon postponement order. Required information. Ex parte void 1936 SWA 3941. Nature, value, and title of claimed assets. Potential prejudice if postponement is denied. Proposed safeguards for the insolvent estate. Protection against risks. Van Schalkwijk v. Dijmeester 1975, 2, SA 508, N. Fraudulent disposal, damage, or theft of assets must be prevented. Court must ensure adequate protection before granting postponement. Next. Page 6.2 Release of solvent spouse's property by trustee. 6.2.1 Categories of property which must be released. I. Property owned before marriage to the insolvent. Trustee must release property that belonged to the solvent spouse before marriage, or before the 1st of October 1926, S21-2A. 2. Property acquired under a marriage settlement. Trustee must release property obtained by the solvent spouse under a marriage settlement, S21-2B. Solvent spouse does not need to prove good faith for the settlement under S21. However, good faith is required to prevent a donation from being set aside as a disposition without value under S27, C12, .2.12. Dobrin v. Trustees Estate Dobrin 1932 WLD 195, S27 and S21, are independent of each other. Turnbull v. Van Zyl No 1974, 1, SA 440, C. Antenuptial contracts are interpreted like any other contracts. If terms are too uncertain, the donation cannot be enforced. Example, a clause settling all household furniture and effects was too vague to be enforced. Natal Joint Municipal Pension Fund v. Endumini Municipality 2012, 4, SA 593, SCA. Leading case on contract interpretation. 3. Property acquired by valid title during the marriage. Trustee must release property acquired by solvent spouse by a valid title against creditors, S21-2C. Includes property bought using personal earnings. Proceeds of personal property. Donations from family/friends, cf. Bernard v. Klein No 1992, SA 306, W. Donations between spouses now valid, S22 Matrimonial Property Act 88 of 1984, but must meet S5 General Law Amendment, Act 50 of 1956, written contract, signed with 2 witnesses. Renz v. Gutman No and others 2003, 1, SA 93, C. 98. If the solvent spouse acquired an asset via a direct gift or funds from the insolvent, the trustee must release it. The purpose of the donation, for example, shielding assets from creditors, does not change this. However, the trustee may later challenge the transaction under S26 as a disposition without value, C12, 2 on. Transactions must be genuine and in good faith. If simulated or collusive to defraud creditors, trustee can disregard them. Snyman v. Reader No. 1989, 4, SA 496, T. Euster v. DeWitt No. 1999, 2, SA 355, T. Betty No. v. Van de Westhuizen 1999, 3, SA 913, SCA 917. Key factor is whether parties knew of insolvency. 4. Property protected under other provisions. S21(2)d provides for release of property protected by other laws, but this provision is obsolete. S44(1) and 2 Insurance Act 27 of 1943, protecting life insurance ceded to a solvent spouse, was declared unconstitutional. Brink v. Kitchoff No. 1996, 4, SA 197, CC. Insurance Act 27 of 1943 replaced by Long-Term Insurance Act 52 of 1998, which has no similar provision. V. Property acquired with proceeds of the above. Trustee must release property obtained using assets previously released. Income or proceeds from these assets, S21(2)e. 6.2 Onus of proof. Solvent spouse bears the burden of proof to show property falls into one of the categories. Maudsley v. Maudsley's Trustees 1940 WLD 166-169. If trustee raises collusion concerns, and the solvent spouse fails to provide a credible response, the court may find the onus not discharged. Cf. Betty No. v. Van de Westhuizen 1999, 3 SA 913, SCA. If solvent spouse gives a plausible explanation and the trustee fails to contradict it, she may succeed. Bernard v. Klein No. 1992, SA 306, W. Solvent spouse proved she bought property using sale of engagement ring plus family donations. Trustee provided no contradictory evidence. Court accepted the explanation despite strange features. Sally Amin v. Smith No. 2009 JDR 1363, GSJ, Para 20. Solvent spouse claimed her husband donated property 10 years before sequestration as compensation for quitting work to raise children. Court accepted the explanation, as the trustee did not challenge it. Davis v. Van den Heever No. 2019 JDR 0536, GJ, Para 30. Augustine v. Haywood No. 2019 JDR 2498, LP, Para 22. No rule prevents spouses married out of community of property from supporting each other financially. Meyerowitz v. Mocheka 2014 JDR 2456, GJ, Para the 12th of April 1958. Not a case of asset protection but family cooperation during crisis. Insolvent's bond payments did not negate the wife's ownership of the property. Next. Page 6.2 Release of solvent spouse's property by trustee. 6.2.1 Categories of property that must be released. The trustee must release the solvent spouse's property if it falls into any of the following categories. Property owned before marriage to the insolvent. Includes property owned by the solvent spouse before marriage, or before the 1st of October 1926, S21(2)a. Property acquired under a marriage settlement. Property acquired under a marriage settlement must be released, S21(2)b. Proof of good faith in the settlement is unnecessary for release but is required to prevent the donation from being set aside under S27. Dobrin v. Trustees Estate Dobrin 1932 WLD 195, S27 and S21 operate independently. Turnbull v. Van Zyl No. 1974, 1, SA 440. Seat antenuptial contract donations must be clear and enforceable. Natal Joint Municipal Pension Fund v. Endumini Municipality 2012, 4, SA 593. SCA leading case on contract interpretation. Property acquired by valid title during the marriage. Includes property purchased with the solvent spouse's earnings, personal property proceeds, and gifts from family and friends, S21(2)c. Bernard v. Klein No 1990, 2, SA 306, W. Property acquired with independent funds must be released. Matrimonial Property Act 88 of 1984, S22 Donations between spouses are now valid but must meet S5 of the General Law Amendment, Act 50 of 1956, must be in writing and signed. Renz v. Gutman No and others 2003, 1 SA 93, c. 98. A donation intended to shield assets from creditors does not affect its validity, but it may be set aside under S26. Snyman v. Reader No 1989, 4 SA 496, t. Euster v. DeWitt No 1999, 2 SA 355, t. Transactions must be genuine and not collusive. Betty No v. Van de Westhuizen 1999, 3 SA 913, SCA 917. Awareness of insolvency at the time of transaction is a key factor in determining good faith. Property protected under other provisions. S21(2)d previously referred to protections under S44 of the Insurance Act 27 of 1943, but this has been declared unconstitutional. Brink v. Kitchoff No 1996, 4, SA 197, cc, and is now obsolete. Property acquired with proceeds of released property. Property acquired with released property, its income, or its proceeds must also be released, S21(2)e. 6.2 Onus of proof. The solvent spouse must prove that the property falls within a category eligible for release. Maudsley v. Maudsley's Trustees 1940 WLD 100 and 66 169. If the trustee raises collusion concerns, and the solvent spouse fails to adequately address them, she fails to discharge her onus. Betty No v. Van de Westhuizen 1999, 3, SA 913, SCA. If the solvent spouse presents a plausible explanation, and the trustee fails to refute it with evidence, the court may rule in her favor. Bernard v. Klein No 1990, 2, SA 306, W. Court accepted the solvent spouse's explanation despite strange features. Sally Amin v. Smith No 2009 JDR 1363, GSJ, trustee failed to challenge a plausible donation claim, so the court accepted it. Davis v. Van den Heever No 2019 JDR 0536, GJ, Augustine v. Haywood No 2019 JDR 2498, LP, spouses married out of community of property can support each other financially. Meyerowitz v. Mochecker 2014 JDR 2456, GJ, court distinguished between fraudulent transfers and genuine family financial cooperation. 6.2.3 Procedure for release of property. The Act does not specify a procedure for obtaining release. Van Dyke v. Donovan Theodore Midget Incorporated 2021 JDR 2591, FB. The solvent spouse may apply to the trustee with an affidavit, supporting documents, invoices, receipts, bank records, and third-party affidavits. Approach the court directly. Hawkins v. Cohen No 1994, 4, SA 23, W. The trustee must assess the claim objectively. De Villiers v. Estate de Villiers 1930 CPD 387-388. If an asset is proven to qualify for release on a balance of probabilities, the trustee must release it immediately. Conrad v. Conrad's Trustee 1930 NPD 100. Creditors cannot prevent the trustee from releasing the property. Inyati Resources Limited and another v. Thorn No and another 1984, 2, SA 551, C. 6.2.4 Effect of release by trustee. The trustee can later reclaim released property if he proves it belongs to the insolvent estate, S2112. The court may interdict the solvent spouse from selling or encumbering released property while litigation is pending. Inyati Resources Limited and another v. Thorn No and another 1984, 2, SA 551, C. 6.3 Release of property by court. If the trustee refuses to release property, the solvent spouse may apply to the court under S2142. Order the release of the property. Stop its sale. Claim proceeds if the property has already been sold, but not yet distributed. The solvent spouse need not apply to the trustee first, but doing so may reduce cost risks. Hawkins v. Cohen, No. 1994, 4, SA 23, W. The court has discretion to issue a just and equitable order, including considering exceptional circumstances. Vanderburg v. Insolvent Estate, Vanderburg 1931 CPD 1. Once the court orders release, it is final and binding. Res judicata, Rutenbach v. Morris, in Re Estate Rutenbach 1961, 3, SA 728, E 6.4 Rights of solvent spouses creditors, in respect of property not released. The solvent spouse's separate creditors may prove claims against the insolvent estate. They share in the proceeds of non-released property before creditors of the insolvent estate, S21.5. Creditors must excuss the solvent spouse's released property before sharing in proceeds, S21.6. To share in the proceeds, a creditor must prove excussion with an affidavit and supporting evidence, S21.7. Include any unrecovered excussion costs in their claim, S21.7. Failing to excuse or provide an affidavit within the master's fixed period forfeits their right to share in proceeds, unless the court decides otherwise, S21.8. 6.5 Sequestration of solvent spouse's estate. The solvent spouse cannot surrender her estate while it vests in the trustee, ex parte venta 1931 SWA 3. However, creditors may still institute civil proceedings against her. Malcolm S. Estate v. de Kock 1937 EDL 18. The solvent spouse's creditors can apply for sequestration if she commits an act of insolvency. Mosenthal Brothers Limited and Another v. Moritz 1929 WLD 84. The court may postpone sequestration if proceedings are underway to release property, make an interim order if property has been released, and the spouse can now pay her debts, S2111. If sequestrated, her trustee gains the right to apply for property release. Suter No v. said No 1957, 3, SA 457, W. Next page. Chapter 7, Uncompleted Contracts and Legal Proceedings Not Yet Finalized. 7.1 Contract completed by insolvent, but not by other party. If the insolvent has fully performed, the right to performance by the other party becomes an asset in the insolvent estate and vests in the trustee. If the right is for payment, the trustee may enforce it as a debt, CFS 77. If the right is for another type of performance, the trustee may sell the right with other estate assets, enforce performance, and then sell the subject matter. Debtors must perform to the trustee, not the insolvent. Performance to the insolvent is generally unlawful unless made in good faith, without knowledge of sequestration, S22. Rights under an indemnity insurance policy vest in the third party who may recover from the insurer, S156, C5.3.8i. 7.2 Contract not completed by insolvent. General common law principles apply, supplemented by statutory provisions. 7.2.1 Continuance of contract at common law. General rule: sequestration does not terminate a contract. Bryant and Flanagan, Proprietary, Limited v. Muller 1978, 2, SA 807, A. 812, Netcor Investment Bank v. Pretoria Belgrave, Hotel 2003, 5, SA 189, SCA 192. Treatment depends on type of contract, whether the insolvent party has fully performed before sequestration, application of relevant law, common law/statute. Example: if the insolvent is a lessor, the principle of Horgat for coup applies, see 7.6.1 and 15.2.5. Exceptions to the general rule. Mandate, mandatum. A contract of mandate, for example, attorney-client relationship, generally terminates on insolvency of the mandator. Goodrich and Son v. Auto Protection Insurance 1968, 1, SA 717, A. 722. However, this is debated. If the mandate does not require special skill, the trustee may enforce it. Klein v. South African Transport Services 1992, 3 SA 509, W. 513. Partnerships. If a partner's estate is sequestrated, the partnership dissolves. South African Loan, Mortgage and Mercantile Agency Limited, v. Burkett 1885, 6, NLR 77. If the partnership estate is sequestrated, the partnership is dissolved. Kassim v. The Master 1962, 4, SA 601, N. 606. 7. 2. The trustee's election at common law. The trustee has a choice to either repudiate the contract, perform the contract if beneficial to the estate. The trustee's election is not a power to terminate the contract but to deny the other party specific performance. Smith v. Parton No. 1980, 3, SA 724, D. 728-9, Ellerine Brothers v. McCarthy Limited 2014, 4, SA 22, SCA. The election must be in the best interest of creditors. Glenn Finance v. Joint Liquidators 1981, 1, SA 171, A. 182. The trustee must abide by creditors' instructions and cannot act against their interest. Ward v. Barrett No. 1963, 2, SA 546, A. The election is final once made. Gordon No. v. Standard Merchant Bank Limited 1983, 3, SA 68, A 95. If no decision is made in a reasonable time, the contract is presumed repudiated. Tangi v. Zivs Trustee 1961, 1, SA 449, W. If the trustee does not perform, the other party may cancel the contract. Ellerine Brothers v. McCarthy Limited 2014, 4, SA 22, SCA. Exception. If the trustee elects to take transfer of immovable property the insolvent port, but had not yet received, the trustee must honor resale or cession contracts. Vision Projects v. Cooper Conroy Bell 1998, 4, SA 1182, SCA 1189. _ Do you want me to continue summarizing the rest of the chapter? Next. Page 7.2.3 Consequences of repudiating a contract. If the trustee repudiates the contract, or is deemed to have done so, the opposite party cannot obtain an order of specific performance, even if fully performed, can pursue other breach of contract remedies. Trustee's repudiation is treated like an unlawful repudiation by a solvent party. Sumcham, Proprietary, Limited v. Federated Insurance Company Limited, and another 1983, 4, SA 609, C. 615-16. If the opposite party disregards the repudiation and keeps the contract alive, may claim damages in lieu of performance but must render their own counter-performance. If the opposite party cancels the contract, can reclaim property handed over in performance, if still owned. Smith and another v. Parton No. 1980, 3, SA 724, D. Must make restitution unless a forfeiture clause excuses them. DeWitt No. v. Ace No. N. Ander 1998, 4, SA 694, T. 705, Tangi and others v. Zivs Trustee 1961, 1, SA 449, W. 453, has a concurrent claim for property transferred, payments made, losses suffered due to breach. Smuts, Trustee of Neertling v. Neertling, 1844, 3 Mens 283-286, Harris v. Trustee of Buisson, 1840, 2 Mens 105, Gordon No. v. Standard Merchant Bank Limited 1983, 3, SA 68, A 90. 7.2.4 Consequences of abiding by the contract. Trustee who continues the contract steps into the insolvent's shoes can enforce performance owed by the other party, must perform obligations under the contract. Ward v. Barrett No. and another No. 1963, 2, SA 546, A. 554, Ellerine Brothers, Proprietary, Limited v. McCarthy Limited 2014, 4, SA 22, SCA 26. Cannot claim preferential treatment due to sequestration. Eastern Metropolitan Substructure of the Greater Johannesburg Transitional Council v. Ventano, 2001, 1, SA 360, SCA 369. Case Law, Bryant and Flanagan, Proprietary, Limited v. Muller and Another No 1978, 2, SA 807, A.M. contracted with TCO for building work. TCO was liquidated, and B and F were appointed liquidators. M continued work, but B and F argued M only had a concurrent claim for pre-liquidation work. Court ruled liquidators were liable to pay in full for the pre-liquidation work since they chose to continue the contract. Defenses and rights of opposite party. If the trustee demands performance without full counter-performance, the opposite party can raise exceptio non odempleti contractus, Frank v. Premier Hanners CC 2008, 3, SA 594, C. Smith v. Van den Heever and others 2011, 3, SA 140, SCA. Trustee is only liable for reciprocal obligations. Nedcor Investment Bank v. Pretoria Belgrave Hotel, Proprietary, Limited 2003, 5, SA 189, SCA 193. Performance costs are administration expenses. Montelando Companhia Naviera SA v. Bank of Lisbon, and SA Limited 1969, 2, SA 127, W. 142. Rights of opposite party in case of breach. The opposite party can raise any defenses they had against the insolvent, Thomas Construction, Proprietary, Limited in liquidation, v. Grafton Furniture Manufacturers, Proprietary, Limited 1988, 2, SA 546, A. 567-8. If the opposite party had the right to cancel the contract before sequestration, they can still exercise that right. Smith and Another v. Parton No 1980, 3 SA 724, D. Even if the default notice period was ongoing at sequestration, the opposite party can cancel. Porteous v. Stridham No 1984, 2, SA 489, D. Key principle: right to cancel is determined at the time of cancellation. Ellerine Brothers, Proprietary, Limited v. McCarthy Limited 2014, 4, SA 22, SCA 28-9. Next page. 7.3 Purchase and sale of immovable property. 7.3.1 Sequestration of purchaser's estate. Trustees' election, common law and statutory provisions. Trustee of the purchaser's insolvent estate may choose to uphold or repudiate the sale. Insolvency Act S35, no specific timeframe for election. The seller must initiate by written notice. Trustee must elect within 6 weeks of receiving notice from the seller. If no election is made, the seller may apply to court to cancel the contract and regain possession. Submit a concurrent claim for damages due to non-fulfillment. If the trustee elects to uphold the contract, they must perform all obligations. Joas Estate v. IV 1947, 4, SA 480, T. Seller may sue for the purchase price and must pass transfer. Ace and Another v. Sam Friedman Limited 1935 AD 165. Exception: if the seller can establish a breach of contract, they may cancel. Provisional trustee's role. Definition: trustee includes provisional trustee, S2, S18-3. If called to act, the provisional trustee must seek directions from the master, S18-2. If no response from the master, may act at own discretion, S18-3. Read with S81-1H and 3, Bota v. von Wright No 1962, 1, SA 863, T. Trustee takes directions from creditors, S81. Application to composite contracts, mixed property sales, Cumming v. Patterson No 1954, 2, SA 130, ES 35 applies to sales including both movable and immovable property. Tangney and others v. Zivs Trustee 1961, 1, SA 449, W. S35 applies only to sales of immovable property. Criticism of Tangney could lead to absurd results where minor movables in a sale exclude S35 application. Preferred approach: if the main purpose is the sale of immovable property, S35 should apply. 7.3. 2. Sequestration of seller's estate. Common Law and Insolvency Act S21A rule: if the seller becomes insolvent before transfer, the immovable property falls into the insolvent estate. S21A. Harris v. Trustee of Buisson, 1840, 2 Mens 105, adopted from Hollandic law. Trustee may elect to uphold or repudiate the sale. If upheld, the trustee must perform the seller's obligations. If repudiated, purchaser, even if they paid in full, cannot demand transfer. Instead, they become a concurrent creditor with a claim for repayment and damages. Gordon No v. Standard Merchant Bank Limited, 1983, 3, SA 68, A 90. Trustee will rarely uphold the contract, as immovable property is often one of the estate's most valuable assets. Many concurrent claims go unpaid due to lack of funds in the estate. Protection under the Alienation of Land Act, S22 Chapter 2, applies when land is sold on installments. Aims to protect buyers where ownership is delayed but payments have begun. Protects buyers paying 2 or more installments over a period exceeding 1 year. S1. Purchasers of land used for residential purposes, excludes agricultural land. Key rights under the Act. Buyer can compel the trustee to transfer land if they arrange to pay outstanding purchase price or largest of. Insolvency Act S89(1) costs, endowment, development, or betterment levies. Mortgage bond settlement, S22(1). If intermediary sales exist, an intermediary or remote purchaser can claim transfer if they fulfill their own contractual obligations. All previous intermediaries' obligations are fulfilled, S22(5), read with S18(1). If no claim for transfer is made, trustee may sell the land. Purchaser with a recorded contract has a preferred claim in the proceeds, S25. Notification requirements. Remote purchasers must immediately notify the original owner of the sale, S21(1). Owner must inform trustee of all purchases within 14 days of insolvency, S21(2)(a). Mortgagee must notify trustee within 10 days of insolvency if a sale has occurred. Trustee must notify buyers and intermediaries as soon as practicable of their rights, S21(2)(b). 7.3.2.3. The Saravitz Exception Constitutional Protection for Vulnerable Purchasers. Saravitz v. Merits No. and another 2015, 4, SA 491, CC, issue. The Alienation of Land Act protected installment buyers but not cash buyers. Finding: this omission was unconstitutional, violating the right to adequate housing, S26 of the Constitution. Remedy ordered by the Constitutional Court. Words including residential property paid for in full within 1 year of the contract, by a vulnerable purchaser added to S1A of the Act. Definition of vulnerable purchaser added: a buyer at risk of homelessness due to seller's insolvency, on installments removed from the title of Chapter 2. Sections 21(2) and 22 apply to vulnerable purchasers who paid the full purchase price within 1 year before insolvency. Protection only applies if the insolvent estate is not yet finalized. Key takeaways. 1. Purchaser's estate and insolvency. Trustee may elect to uphold or repudiate the sale. S35 requires trustee to decide within 6 weeks of seller's written notice. Failure to elect allows seller to cancel the contract and claim damages. 2. Seller's estate and insolvency. Common Law and S21A of the Insolvency Act. If seller goes insolvent before transfer, property falls into insolvent estate. Purchaser becomes a concurrent creditor. Alienation of Land Act S22. Protects buyers purchasing land on installments. Buyers may compel transfer if they fulfill contractual obligations. 3. Saravitz Exception Constitutional Protection. protects vulnerable buyers who paid the full price within 1 year before insolvency, ensures transfer of residential property to prevent homelessness. Court-ordered statutory amendments to the Alienation of Land Act. Next. Page 7.4 Installment Agreement regarding movable goods. 7.4.1 Sequestration of buyer's estate. Special rules apply when the insolvent buyer purchased movable goods under an installment agreement per S1 of the National Credit Act 34 of 2005, specifically under paras A, B, and CI of the definition of installment agreement. Effect of sequestration. S84(1) of the Insolvency Act. Upon sequestration, the seller automatically acquires a hypothec over the goods securing the outstanding balance. Since ownership cannot be retained by the seller over his own property, ownership transfers to the insolvent estate. Seller loses ownership but becomes a secured creditor with a hypothec over the goods. Trustee must deliver the goods to the seller if requested, after which the seller holds them as security for the debt and may realize them as a secured creditor. Definition of Installment Agreement, S1 of NCA 34 of 2005. Prices deferred, paid in periodic payments. Possession and use of goods are transferred to the consumer. Ownership passes to the consumer only after full compliance with the agreement. Even if the agreement falls outside the NCA, S84(1) of the Insolvency Act still applies. Podgaita Novi Daewoo Heavy Industries 2003, 3, SA 98, SCA 100-2. Unclear position. Whether a sale where the price is payable in one lump sum at a future time qualifies as an installment agreement is uncertain. Cf. Sandoz Products, Proprietary, Limited v. Van Zyl 1996, 3, SA 726, C. Okabona 2000 Electrical CCV City Power Johannesburg 2004, 6, SA 323, SCA 327. Movables refer to corporeal, tangible, movables. The sale of a business does not fall under this provision. 18 Drankwinkle BKV Bota NNO 1994, 1, SA 1, A 17. Applicability of S84(1) only applies if the agreement is still in force at the time of sequestration. If the seller cancelled the agreement before sequestration due to buyer's default, S84(1) does not apply, unless the buyer reinstates the agreement under the NCA. Absa Bank Limited v. Cooper No 2001, 4, SA 876, T. PMG Motors Kailami, Proprietary, Limited v. First Rand Bank Limited, Westbank Division 2015, 2, SA 634, SCA 646. Seller must still be the owner of the goods for a hypothec to arise. Okabona 2000 Electrical CCV City Power Johannesburg, Proprietary, Limited 2004, 6, SA 323, SCA 328. Effective trustee is not in possession. Conflicting decisions on whether S84(1) applies if the goods were sold to a third party before sequestration. UDC Bank Limited v. CCAT Leasing and Finance 1979, 4, SA 682, T. Seller does not lose ownership if trustee is not in possession. Hubert Davis Water Engineering v. The Body Corporate of the Village 1981, 3, SA 97, D. Trustee must take possession and return goods to seller unless physically impossible or a third party holds superior rights. Venta Novi Often, Proprietary, Limited 1996, 1 SA 826, A. Confirmed Hubert Davis approach, trustee must obtain possession if not already in possession. S84(2) of the Insolvency Act. If buyer returns the goods to the seller within 1 month before sequestration, the trustee may demand their return or equivalent value, subject to certain deductions. Purpose: prevent situations where buyer returns high-value goods, but only a small amount of the purchase price has been paid. Trustee's payment is a cost of administration under S97 of the Insolvency Act. If payment is made, seller loses ownership. Pretorius and Van de Viver, 1973, 36 THR HR 396, 410-11. Not applicable if the contract was cancelled before sequestration. PMG Motors Kailami, Proprietary, Limited v. First Rand Bank Limited 2015, 2, SA 634, SCA 646-7. If seller pays instead of returning the hypothecated goods, they may claim unjust enrichment. 7.4 to sequestration of seller's estate. Nature of contract. Goods are sold on installments, and the seller retains ownership until the buyer has fully paid and met obligations. No special provisions in the Insolvency Act for this scenario. Legal debate on trustees' powers. Some academics argue that if the seller becomes insolvent, but the buyer continues paying, the trustee cannot repudiate the contract and reclaim the goods. No clear case law supports this exception to general insolvency principles. Trustee generally has the right to repudiate the contract, recover the goods since ownership remains with the seller's estate. Buyer would have only a concurrent claim for damages. 7.23. Next page. 7.4 Installment Agreement regarding movable goods. 7.4.1 Sequestration of buyer's estate. Applicable rules. Special rules apply when an insolvent buyer has purchased movable goods under an installment agreement as defined in S1 of the National Credit Act 34 of 2005, NCA. S84(1) of the Insolvency Act. On sequestration of the buyer's estate, the seller automatically acquires a hypothec over the res vendita, goods sold, securing the outstanding balance. Effect of sequestration. Seller loses ownership of the property. Property passes into the insolvent estate, as no one can have a hypothec over their own property. The seller becomes a secured creditor. The trustee must deliver the property to the seller, who holds it as security for the outstanding debt. Williams Hunt Vereniging, Limited v. Slomovitz 1960, 1, SA 499, t. Definition of an installment agreement, S1 NCA. Part or all of the price is deferred and paid in installments. Possession and use are transferred to the consumer. Ownership transfers only once the agreement is fully complied with. Legal uncertainty and case law. Unclear whether an installment agreement includes lump sum future payments. Sandals Products, Proprietary, Limited v. Van Zyl No 1996, 3, SA 726, c. Okabona 2000 Electrical CCV City Power Johannesburg 2004, 6, SA 323, SCA. Corporeal movables fall under this rule, but a business sale does not. 18 Drankwinkle BKV Bolter NNO 1994, 1, SA 1, A. Cancellation and ownership considerations. S84(1) applies only if the agreement is still in force. If the seller cancelled the contract before sequestration, no hypothec arises. ABSA Bank Limited v. Cooper No 2001, 4, SA 876, t. PMG Motors Kailami, Proprietary, Limited v. First Rand Bank Limited 2015, 2, SA 634, SCA. The seller must be the actual owner to claim a hypothec. Okabona 2000 Electrical CCV City Power Johannesburg 2004, 6, SA 323, SCA. Trustee's possession and case law. If the trustee is not in possession, must obtain it. Venta no Viofin, Proprietary, Limited 1996, 1, SA 826, A. Conflicting decisions reconciled. UDC. Bank Limited v. CCAT Leasing and Finance Company, Proprietary, Limited 1979, 4, SA 682, t. Trustee not in possession, seller retains ownership. Hubert Davis Water Engineering v. The Body Corporate of the Village 1981, 3, SA 97, d. Trustee must recover and deliver the property. Venta no Viofin, Proprietary, Limited 1996, 1, SA 826, A. Adopted Hubert Davis ruling, trustee is obligated to recover the property. Return of property before sequestration. S84(2) Insolvency Act. If the buyer returns the property within 1 month before sequestration, trustee can demand delivery or payment of its value. The seller can deduct the outstanding amount from the value of the goods. Ensures concurrent creditors benefit when unpaid. S84(2) does not apply if the contract was cancelled pre-sequestration. PMG Motors Kailami, Proprietary, Limited v. First Rand Bank Limited 2015, 2, SA 634, SCA. 7.4, to sequestration of seller's estate. Ownership retention and trustees' rights. A seller who retains ownership until full payment has no statutory protection under the Insolvency Act. Some academic opinion suggests that the trustee cannot repudiate the contract if the buyer continues payments. No clear case law supporting this view. Trustees' election. If the seller is sequestrated before full payment, trustee steps into the seller's position, can elect to uphold or repudiate the contract. If repudiated, trustee recovers the goods, and the buyer only has a concurrent damages claim. 7.5 Sale of movable property under a contract that is not an installment sale. 7.5.1 Credit sale of movable property. Ownership transfer. Ownership transfers on delivery, unless contract states otherwise. If the seller is sequestrated before payment, trustee claims the purchase price and enforces the buyer's obligations. If the buyer is sequestrated before payment, ownership has already passed to the insolvent buyer. The seller only has a concurrent claim against the insolvent estate. S21 Insolvency Act. 7.5 Cash sale of movable property. Ownership transfer. Ownership transfers only after full payment and delivery. If the seller delivered the goods but was not paid, they typically have a contractual right to cancel and reclaim the goods. However, S36(1) and 4 of the Insolvency Act limits this right. Seller must give written notice within 10 days of delivery, not sequestration. If the trustee objects, the seller must institute legal proceedings within 14 days. Effect of failing to give notice. If no statutory notice is given, the seller loses the right to reclaim goods. S36(4), Cornelison No v. Universal Caravan Sales, Proprietary, Limited 1971, 3, SA 158, A. The seller then only has a concurrent claim for the unpaid price. Trustees' rights. The trustee may refuse to return the property unless refunded any amounts already paid. S36(3). S36 does not apply to installment agreements governed by the NCA, C7.4.1. Next page. 7.5 Sale of movable property under a contract that is not an installment sale. 7.5.1 Credit sale of movable property. In a credit sale, the price is payable after delivery. Ownership passes to the buyer on delivery unless otherwise agreed. If the seller is sequestrated before payment, the trustee may claim payment and enforce the buyer's obligations. If the buyer is sequestrated before payment, ownership has already passed to the buyer. The property vests in the trustee. S21 Insolvency Act. The seller has a concurrent claim for unpaid obligations. 7.5 Cash sale of movable property. Ownership passes only after delivery and full payment. The Insolvency Act restricts the seller's right to cancel for non-payment. S36(1) and 4 Insolvency Act. The seller can reclaim goods only if written notice is given, within 10 days of delivery, not sequestration. If the trustee objects, the seller must initiate legal proceedings within 14 days. If the seller fails to give statutory notice, they lose the right to reclaim goods. S36(4), Cornelison No v. Universal Caravan Sales, Proprietary, Limited 1971, 3, SA 158, A. 180. The seller then has only a concurrent claim for the unpaid purchase price. The trustee may refuse to return the goods unless refunded the received purchase price. S36(3). S36 does not apply to installment agreements under the National Credit Act 34 of 2005. Underscore. 7.6 Lease. 7.6.1 Sequestration of lessor's estate. The lessor's sequestration does not automatically terminate the lease, nor its industrial properties, proprietary, Limited v. Monarch SA Insurance Company Limited 1987, 1, SA 827, A 837, Ellerine Brothers, Proprietary, Limited v. McCarthy Limited 2014, 4, SA 22, SCA 26-7. The trustee can uphold or repudiate the lease but typically seeks to realize assets for creditors. Movable property leases, for example, cars, are not protected. The trustee can terminate them. Immovable property leases are protected under the Hogarth-Coupe rule. The lease continues even after the property is sold. Shell Rhodesia, Proprietary, Limited v. Eliasov No 1979, 3 SA 915, R 917. If the lease was concluded before a real right, for example, mortgage, was registered, the lessee prevails. Absa Bank Limited v. Sweet and Others 1993, 1, SA 318, C. 324. If the real right was registered before the lease, the trustee may have to repudiate the lease if required by the real right holder. Tim v. K 1954, 4, SA 585 T. The property must be sold subject to the lease unless the highest bid does not cover the mortgage debt, in which case it may be sold free of the lease. Velkich v. Land and Agricultural Bank of South Africa 1996, 1, SA 17, A 7.6.2 Sequestration of lessee's estate. S37 Insolvency Act governs the effect of lessee's sequestration. The trustee can elect to uphold or repudiate the lease. Ellerine Brothers, Proprietary, Limited v. McCarthy Limited 2014, 4, SA 22, SCA 28. Rules under S37. The trustee must give written notice to repudiate the lease. S37-1. If no notice is given within 3 months of appointment, the lease is deemed repudiated. S37-2. The trustee requires authority from creditors or the master before continuing the lease. SS 81-1H, 81-1 bis, 81-3. Special cases. Montelando Companhia Naviera SA v. Bank of Lisbon, and SA Limited 1969, 2, SA 127, W. S37 applies to leases of movables and immovables, but not to certain charter parties. MV Silver Star 2015, 2, SA 331, SCA. Time/voyage charter parties are not leases. MV Madiba 1, 2022, JOL 54278, WCC. Demise charter parties are leases and subject to S37. Labor tenancies are not leases and are governed by common law. Zulu v. Van Rensburg, 2011, JOL 24875, LCC, 22-5. Lessor's rights in case of repudiation. If repudiated, the estate loses the right to compensation for improvements unless agreed with the lessor. S37-4. The lessor has a preferred claim for rent from sequestration until lease termination, included in administration costs. S37-3. A secured claim for pre-sequestration rent via tacit hypothec, limited by the Act. A concurrent claim for damages due to breach of contract, nor its industrial properties, proprietary, Limited v. Monarch SA Insurance Company Limited 1987, 1, SA 827, A. Sureties remain liable despite sequestration. Boshoff v. SA Mutual Life Assurance Society 2000, 3 SA 597, C. Next page. 7.6 Lease. 7.6.1 Sequestration of lessor's estate. Common law applies. Sequestration of lessor's estate does not automatically terminate the lease. Cases nor its industrial properties, proprietary, Limited v. Monarch SA Insurance Company, Limited 1987, 1, SA 827, A 837, Ellerine Brothers, Proprietary, Limited v. McCarthy Limited 2014, 4, SA 22, SCA 26-7. Trustee has discretion to uphold or repudiate the lease but must realize assets to pay creditors. Movable property. Lease is typically terminated to facilitate asset realization. Immovable property. Rule Hogarth Vorkoop, hire before sale, protect sitting tenant. Applies only to land/buildings, not movables. Graham v. Local and Overseas Investment, Proprietary, Limited 1942 AD 95 100, and 10-11, Genoway Properties, Proprietary, Limited v. Mediotronics, Natal, Proprietary, Limited 1995, 2, SA 926, A, 932. Trustee cannot repudiate lease but must sell property subject to lease. Shell Rhodesia, Proprietary, Limited v. Eliasov No 1979, 3 SA 915, R 917. If lease predates a real right. For example, mortgage bond, lease prevails Absa Bank Limited v. Suite and Others 1993, 1, SA 318, C. 324. If real right was registered before lease, trustee may be compelled to repudiate lease. If sale subject to lease does not cover real right claim, property must be sold free of lease. Tim v. K. and Another 1954, 4, SA 585, T. Oosthuizen and Another v. Murray and Others, 2015, Jol 32431, GJ. Lessee has a concurrent claim for damages if lease is repudiated. Shell Rhodesia, Proprietary, Limited v. Eliasov No. Case, Valkich and Others v. Land and Agricultural Bank of South Africa, and Others 1996, 1, SA 17. A property was sold free of lease without following correct procedure. Court upheld sale, assuming correct procedure would not have changed the outcome. This assumption was criticized. Kritzinger, 1996, 113, Sag 209. Trustee must prove sale subject to lease would not have satisfied mortgage. Shell Rhodesia, Private, Limited v. Eliasov No 921 Obita. 7.6. To sequestration of lessee's estate. Controlled by S37 of Insolvency Act, aligns with common law. Ellerine Brothers, Proprietary, Limited v. McCarthy Limited 2014, 4, SA 22, SCA 28. Trustee may choose to continue or repudiate lease. Repudiation process S37. Must be in writing S37-1. If trustee does not confirm continuation within 3 months, lease is deemed repudiated. S37-2. Trustee may need creditor or master's approval. SS 81-1H, 81-1 bis, 81-3. Leases under S37. Includes movable and immovable property. Montelando Companhia Naviera S.A.V. Bank of Lisbon, and S.A. Limited 1969, 2, S.A. 127, W. Demise Charter Party is a lease. MV Madiba 1, Van Niekerk v. MV Madiba 1, 2022, Jol 54278, WCC, Para 25. Pasharian leases, prop sharing agreements, also covered. Nord-Westlike Cooperationland Bumeatskapi BPK Vidai Mista N Ande 1982, 4, SA 486, North Carolina. Labor tenancies are not leases. Zulu and Others v. Van Rensburg and Others, 2011, Jol 24875, LCC, 22-5. Exceptions where lessor may cancel lease. Lessee breached contract before sequestration. For example, non-payment of rent. Mitchell v. Soterilis Trustee 1936 TPD 252. Sequestration of a surety's estate. Zitonics, Proprietary, Limited VK 201250042, South Africa, Proprietary, Limited 2018 JDR 0688, SCA, Paris 7, 12-15. Effects of repudiation, S37-4. Insolvent estate forfeits claims for improvements unless agreed with lessor. Lessor's claims. Prefer claim for rent from sequestration to lease termination, S37-3. Secured claim, if immovable property, via tacit hypothec for rent owed at sequestration, limited under S16, 2. Concurrent claim for damages, Norix Industrial Properties, Proprietary, Limited v. Monarch SA Insurance Company Limited 1987, 1 SA 127, A. Surety remains liable, sequestration does not discharge principal obligation, Boshoff v. South African Mutual Life Assurance Society 2000, 3 SA 597, C_. 7.7 Employment Contract 7.7.1 Sequestration of employee's estate. General rule: sequestration does not affect employment contract, which continues. Exception: insolvent may be disqualified from holding certain positions, see 4.4. 7.7 The sequestration of employer's estate. Employment contract is suspended immediately, S38(1). Employee is not required to work or entitled to salary, S38(2)(a). No employment benefits accrue, S38(2)(b). Employee may claim unemployment benefits, S38(4). Trustee's role in contract termination, S38(4). Trustee must consult relevant parties before termination, S38(5), 7. Consultation includes trade unions, workplace forums or employees directly, S38(5). Employees may propose rescue measures within 21 days, S38(7). Creditors may participate with trustees' consent, S38(8). Sale of business. If business, or part, is sold, employees are transferred to the new employer, Labor Relations Act S197A2. Existing rights and obligations remain, and actions of former employer, for example, unfair dismissals, are still attributable to them. Termination of employment contract. If no resolution is reached, contract automatically terminates 45 days after trustee appointment, S38(9)(a). Upon termination, employee may claim compensation for loss and severance pay, S38(10)(11). Employee's severance pay is a preferred claim, S16(32)(vi). 7.8 Transactions on market infrastructure. Special rules under S35A of the Insolvency Act apply when insolvent is a market participant. Key definitions: Financial Markets Act 19 of 2012. Market infrastructure includes exchanges, clearing houses, central securities depositories, and central counterparties, S35A1. Market participant includes authorized users, participants, clearing members, and clients, S35A1. Rules: exchange, depository, or clearinghouse rules, S35A1. Transaction: any transaction governed by such rules, S35A1. Legal effects. Termination: if market participants' obligations remain unfulfilled at sequestration, counterparties can terminate the transaction under the rules, S35A2. Claims limited: resultant claim is restricted to amount due upon termination, S35A3. Trustee bound by market rules, S35A4. Netting of market participants' position. Set-off of transactions. Opening and closing of positions. Applies even if transaction settlement is due post-sequestration. Next page. 7.7 Employment Contract. 7.7.1 Sequestration of employee's estate. Sequestration of an employee's estate does not generally affect their employment contract. Exception: if a statutory provision disqualifies an insolvent from holding a position or office before rehabilitation, see 4.4. 7.7. The sequestration of employer's estate. Suspends the employment contract immediately, S38(1). Effects of suspension. Employee not required to work and not entitled to salary, S38(2)(a). Employee may claim compensation for losses due to suspension, S38(10)(a). No employment benefits accrue, S38(2)(b), but unemployment benefits may be available, S38(4). Trustee's role. Can terminate the contract after consultation, S38(4). Must consult. Parties required by a collective agreement. If no agreement, then the workplace forum and registered trade union. If neither exists, the employee personally, or a nominated representative, S38.5. Parties must submit proposals in writing within 21 days, S38.7. A creditor may participate with trustee's consent, S38.8. Trustee must consider selling part or whole of the business as a measure, S38.6. Effect of business transfer. The employment contract continues with the new employer, S197A2, Labor Relations Act 66 of 1995. Rights and obligations remain between employee and old employer. Past actions by the old employer, for example, dismissal, unfair labor practices, discrimination, remain enforceable against them, S197A2, Labor Relations Act. Contract termination. If no rescue measure is taken and the trustee does not terminate, the contract automatically ends 45 days after trustee appointment, S38.9a. Upon termination, the employee is entitled to compensation for losses, S38.10. Severance benefits under S41 of the Basic Conditions of Employment, Act 75 of 1997, S38.11. The employee's claim for severance is preferred, C16, D2vi. _ 7.8 Transactions on Market Infrastructure. Regulation. Special rules under S35A of the Insolvency Act govern transactions where an insolvent was a market participant in a market infrastructure. Legislative changes. Market infrastructure replaced exchange in S35A on the 29th of March 2018. Financial Sector Regulation Act 9 of 2017. Amendment in S35A heading on the 29th of April 2022. Financial Sector Laws Amendment Act 23 of 2021. Definitions. Market infrastructure includes Financial Markets Act 19 of 2012. Exchange, S1, licensed under S9. Central Securities Depository, S1, licensed under S29. Clearing House, S1, licensed under S49. Central Counterparty, S1, licensed under S49. Licensed External Central Counterparty, S1. Market Participant. An authorized user, participant, clearing member, or client, S1, Financial Markets Act. Rules. Exchange rules, depository rules, clearinghouse rules, S1, Financial Markets Act. Transaction, any transaction governed by the above rules. Key provisions, S35A, Insolvency Act, sequestration of market participants' estate. If pre-sequestration obligations remain unfulfilled, the market infrastructure or another market participant may terminate the transaction as per the rules. Revoke settlement instructions. The trustee is bound by such termination or revocation. S35A2. Claim limitation. Any claim following termination is limited to the amount due under the rules. S35A3. Trustee obligations. Trustee is bound by exchange rules that provide for netting of a market participant's position, set-off of transactions involving the market participant, opening and closing of the market participant's position. This applies if the transaction is to be settled after sequestration, was overdue at the time of sequestration, S35A4. Next page. 7.9 Agreements providing for termination and netting. Section 35B applies where the insolvent was a party to a master agreement. Master agreement includes agreements under standard terms published by International Swaps and Derivatives Association, International Securities Lenders Association, Bond Market Association, International Securities Market Association, S35B2. Upon sequestration, all unperformed obligations under the agreement terminate automatically, S35B1. Market values of obligations must be calculated, netted, and the net amount paid, EBIT. Exceptions. Section 35B does not apply to transactions under S35A, C 7.8. Does not apply to netting arrangements under the National Payment System Act 78 of 1998, S35B3. 7.10 Provisions designed to protect solvent party. Contract clauses that modify legal consequences of concursus creditorum are void. Test: does the clause confer a preference, power, or unlawful asset distribution? Case law, Vaughan and another NNO, v. the Government 1973, 4, SA 42, T. 46. 7.10.1 Clause reserving ownership in goods until full payment. Supreme Court of Appeal upheld ownership retention clauses in movable goods. Case law, Pelono and another v. Club Refrigeration CC 2006, 1, SA 230, SCA. This prevents goods from vesting in the debtor's insolvent estate. 7.10.2 Clause providing for cancellation on insolvency. Clauses allowing cancellation due to insolvency alone are unenforceable. Deprives the trustee of electing to complete the contract in the best interests of creditors. Section 37(5), lease clauses terminating upon sequestration are null and void. Case law, Slims, Proprietary, Limited and another v. Morris No. 1988, 1, SA 715, A. Exception. Clause allowing a lessor to cancel a lease if a surety's estate is sequestrated was upheld. Case law, Zetonics, Proprietary, Limited VK 201250042, South Africa, Proprietary, Limited 2018, JDR 0688, SCA, Paris 7, 12-15. 7.10.3 Clause providing for vesting or continued use of insolvent's property. Invalid clauses. Vesting clauses, for example, employer acquiring contractor's assets on site due to insolvency. Subcontract assignment clauses, automatic transfer of all subcontracts to employer. Use of property clauses, employer using contractor's property post-insolvency. Reason: such clauses interfere with the trustee's duty to control and sell assets. Case law. Kahan No v. Hydro Holdings, Proprietary, Limited 1980, 3, SA 511, T. 514. Ruin Ande v. Van Rensburg No. 1996, 4, SA 271, A. Commissioner, South African Revenue Service v. Van der Merwe No. and others 2017, 3 SA 34, SCA, 42-3. 7.10.4 Clause providing for direct payment to subcontractors of insolvent. Invalid against the trustee. Employer paying subcontractors directly violates concursus creditorum. Case law. Administrator, Natal v. McGill, Grant and Null, Proprietary, Limited in Liquidation, 1968, 4, SA 44, D. 1969, 1, SA 660, A. Reason: payments made post-insolvency give subcontractors preference over other creditors, disrupting asset distribution. 7.10.5 Clause providing for set-off on insolvency. Set-off clauses cannot be invoked post-insolvency. They give one creditor preference over others. Case law. Thorn and another NNO v. the Government 1973, 4, SA 42, T. Confirmed on appeal, the Government v. Thorn and another NNO 1974, 2, SA 1, A. Applied in Roman Catholic Church, Klerksdorp Diocese, v. Southern Life Association Limited 1992, 2, SA 807, A. 815. Silk Holdings, Proprietary, Limited in Liquidation, TA Workgroup v. Business Connection Solutions, Proprietary, Limited, 2009, 1 All SA 571, SCA, 573-4. 7.11 Legal proceedings commenced before insolvency. Criminal proceedings not affected by sequestration. Civil proceedings automatically stayed until a trustee is appointed, S21B. Party continuing proceedings must give notice to trustee, or master if no trustee, within 3 weeks of the first creditor's meeting. Prosecute with reasonable speed after 3 weeks S75-1. Failure to give notice proceedings lapse, unless court allows continuation for a reasonable excuse, IBID. Substituting the trustee. Application required before proceedings continue, ensuring the correct party is before the court. Execution of judgments. Execution of judgments against the insolvent estate is stayed once the sheriff becomes aware of sequestration, S21C. Even if property is sold, execution is stayed unless transfer occurred. Case law. Seifrieds Bank Limited and others v. Sheriff of the Supreme Court, Durban Central, and another, Sherino v. Seifrieds Bank Limited, and others 1997, 1, SA 764, D, 775-6. Naidu and another v. Matlala No and others 2012, 1, SA 143, GNP, 154. Insolvents imprisonment for debt. An insolvent in prison for debt may apply for release after notifying the creditor, S21D. Redundant provision due to the abolition of civil imprisonment for debt. Case law, Kutsia v. Government of the Republic of South Africa, Mitiso and others v. Commanding Officer, Port Elizabeth Prison, and others 1995, 4, SA 631, CC. Next page. Chapter 8, Preservation of the Estate pending the trustee's appointment. 8.1 Notice of Sequestration and Entry of Caveats. Upon granting a sequestration order, the registrar must transmit one original order to the master S17-1A. The master must publish notice of the order in the Gazette, S17-4. The registrar must send one original of each provisional sequestration order, or final sequestration order, not preceded by a provisional order, to sheriff of every district where the insolvent resides or owns property, every registrar of deeds, every officer in charge of a ship register, every sheriff holding attached property of the debtor, S17-1B. These officers must register the order, S17-2 and, if applicable, enter caveats against transfer of ownership by the insolvent or their spouse, cancellation or cession of any mortgage registered in the insolvent/spouse's name, transfer of ships or shares in a ship, cancellation or cessation of any mortgage on a ship, S17-3A and 3 bis, expiry of caveats. Caveats on immovable property expire 10 years after the sequestration order, S17-3B. Purpose: to notify interested parties and prevent improper dealings with the insolvent's property. 8.2 Service of order and attachment of property. Registrar's duty: must serve the final sequestration order on the insolvent, the solvent spouse, if they have a separate estate not under sequestration, must file with the master a copy of the sheriff's return of service, S16-1. Duties upon receiving the order. Insolvent must hand over all records relating to their affairs to the sheriff, must lodge a statement of their affairs with the master, S16-2. Solvent spouse must lodge a statement of their affairs with the master, S16-3. Sheriff's role in attachment, S19-1. Attach and inventory movable property that is capable of manual delivery, is not held by a person with the right of pledge, retention, or court attachment, must act with reasonable care. Judy Lowett's Trustee v. the Sheriff 1904 TS 800 and 39 842. Interested parties may be present but cannot direct the sheriff on what to attach, S19-2. Sheriff is accountable to the master, not to creditors. Administratrice van die Adrian Oordendal Kindertrust e Adjunct Balu. Harrismith N. Ander 1991, 1, SA 465, 471. Limits of attachment. Does not include incorporeal rights. Turquoise River Incorporated v. McMenamin, and others 1992, 3, SA 653, D, 658-9. Strict interpretation of the sheriff's power. Trustees' control over solvent spouse's property. No explicit provision on how the trustee assumes control over the solvent spouse's property. Held, the trustee must attach the property before dealing with it. Cothill et Oxall v. Cornelius 2004, SA 163, t. 167. Sheriff's specific duties under Section 19(1). Collection and listing of records. Take custody of all books of account, invoices, vouchers, and business records. Make a detailed list and ask the insolvent to confirm its completeness. Failure to list records. Only listed records will be admissible in criminal proceedings against the insolvent, unless proven otherwise. S 19(1) bis. Collection of valuables. Gather cash, share certificates, bonds, bills of exchange, promissory notes, and securities. Any cash collected must be sent to the master. Storage of attached property. Movable property, except animals, must be sealed in a secure location or given to a custodian. The custodian must receive an inventory copy and a notice of attachment. The notice must include a warning of penalties under S 142(4). Concealing property to defeat attachment. Failing to disclose property. Proper animal attachment. The sheriff must take them into physical custody. Administratrice van die Adrian Oordendal Kindertrust via Junk Balu. Harrismith N. and Dare Supra. Reporting duties. Immediately after attachment, the sheriff must report to the master and submit an inventory copy. S 19(3)(a). Report must mention property held under pledge or use retentioners, right of retention. Sheriff must also submit an inventory copy to the trustee after their appointment. S 19(3)(b). Magistrates' court sheriffs must immediately send an inventory of attached property to the master. S 19(4). Next page. 8.3 Curator Bonus. Appointed after the notice of intention to surrender is published. C2.4.2. Continues in capacity even after sequestration until a trustee is appointed. Estate assets do not vest in the curator bonus, only has custody and control. May be attached by the sheriff. Remuneration. Entitled to reasonable remuneration from the estate. S 63(1). Paid as part of sequestration costs. S 97(2)(c). Administrative work. Can hire someone for administrative tasks. Trustee cannot pay an employee at estate expense for trustee's ordinary duties. Case law. Pellow v. Master of the High Court 2012, 2, SA 491, GSJ, Miller and others v. Nufcock Investment Holding Company, Limited and others 2010, 6, SA 390, SCA 8.4 Provisional Trustee. 8.4.1 Appointment. Purpose: manages estate before a trustee is appointed. Authority to appoint. Only the master can appoint a provisional trustee. S 18(1). The High Court has no inherent power to appoint one. Goldfields Trading Company, Proprietary, Limited v. Shooter 1956, 3 SA 1. O. Ex parte the Master of the High Court South Africa, North Gauteng 2011, 5, SA 311, GNP 324, the Master of the High Court, North Gauteng High Court, Pretoria, Vimutala No and others 2012, 3, SA 325, SCA 329. Application for appointment. Creditors or interested persons must apply to the Master. Justifications include continuing business operations, immediate sale of perishables, ministerial policy, Minister of Justice's policy intended for fairness, transparency, and addressing past discrimination. S 158(2). 2014 policy amendments were declared invalid due to overreach and failure to prevent corruption. SA Restructuring and Insolvency Practitioners Association v. Minister of Justice and Constitutional Development, and others 2015, 2, SA 430, WCC. Confirmed by Minister of Justice v. SA Restructuring and Insolvency Practitioners Association 2017, 3 SA 95, SCA. Minister of Justice and another v. SA Restructuring and Insolvency Practitioners Association and others 2018, 5, SA 349, CC. Master's discretion. Discretionary appointments of provisional liquidators, S 368, and co-liquidators, S 374 of the Companies Act 61 of 1973. Ventano and others v. the Master of the High Court, Pretoria and others, 2022, ZAP 578. Court upheld the Master's discretionary power. Applicants' attempt to block co-liquidators was self-serving. Attorney and client costs awarded de bonus procri, from applicants' own funds. Finality of appointments. Master's decisions are final unless reviewed, S 151. DeWitt v. Camisar 2021 JDR 1070, SCA. Master lack power to revoke final appointment of liquidators. 8.4. 2 Rights and duties. Verification of sequestration order. Provisional trustee must confirm the insolvents. Full name, date of birth, ID number, marital status. Spouse's details if applicable, S18A. Reporting requirements. Must correct and submit missing details to the Master and Registrar of Deeds. Powers and restrictions, S18.3. Has trustees powers except. Cannot bring or defend legal proceedings without court authority. Cannot sell estate property without the Master's or court's approval. Unauthorized sales are void. Psy Investments v. Van der Stuyfno and others 1999, 3 SA 340, N 350-2. Master's directions. Can issue directions equivalent to creditor decisions at a duly convened meeting, S 18.2. Limited role. Primary function control and preservation of estate, not winding up. Goodwin Stable Trust v. Duohex, Proprietary, Limited and another 1998, 4, SA 606, C. 620. Courts authorize legal actions or property sales only in exceptional cases. Warwicker and another NNO. v. Liberty Life Association of Africa Limited 2003, 6, SA 272, W. Conditions for authorization. Urgency. Prima facie enforceability of the claim. No prejudice to creditors. 8.4.3 Remuneration. Entitlement. Reasonable remuneration, taxed by the Master, S1 Definition of Trustee, S63.1. Paid as part of sequestration costs, S97.2c. Alternative arrangements. A curator bonus or provisional trustee may not always be necessary. Sheriff may attach and hold assets until a trustee is appointed. Next page. Chapter 9, Meetings of Creditors and Proof of Claims. 9.1 Meetings of Creditors. Meetings allow creditors to establish claims, elect a trustee, and give directions for estate administration. Only creditors of debts incurred before sequestration have rights in these meetings. There are 4 types of meetings. First meeting. Second meeting. Special meeting. General meeting. Usually, only the first and second meetings occur. Formalities for calling meetings can be waived if all parties consent. Leidsno v. Simon 1964, 1, SA 377, T. 9.1.1 First meeting. Convened immediately after final sequestration order, by the Master via Gazette Notice S41. Purpose. Creditors prove claims. Trustee is elected. Gazette Notice must be published at least 10 days before the meeting. S42. Netcall Bank Limited v. the Master 2002, 1, SA 390, SCA. The Master determines the time and place, S39.1, with discretion to alter it if sufficient notice is given. 9.1. 2 Second meeting. Set by the Master after the first meeting and trustee appointment, S43A. Convened by the trustee through notices in the Gazette and local newspapers, S43B. Purpose. Further proof of claims. Trustee presents a report on the estate's condition. Creditors provide directions on estate administration, S43A. Notices must be published in both English and Afrikaans, S43C. 9.1.3 Special meeting can be called for two reasons. 1. Proof of claims, S42-1, trustee convenes upon request of an interested party who pays expenses. Not valid if solely for interrogating witnesses, Marks v. de Villiers 1994, SA 415, W2. Interrogation of insolvent, S42-2, requires master's consent. Can only be used to question the insolvent, not other witnesses. Bernard v. Kleinow 1992, SA 306, W. 9.1.4 General Meeting. Trustee may call a general meeting for estate administration guidance, S41, must be convened if requested by the master or creditors holding 1/4 of proved claims, S41. Also used to consider an offer of composition, Mir v. the Master 1940 TPD 86, Illich v. Paginos 1985, 1, SA 795, A. Cannot be solely for interrogating witnesses unless properly called for directions, Aesop v. the Master 1983, 1, SA 926, C. 9.1.5 General Provisions on Meetings. I. Date and venue. First meeting date/time is fixed by the master. Other meetings are set by the trustee. Presiding officer can adjourn meetings, S39.5. Meetings must be accessible to the public, S39.6. 2. Presiding officer. Master or designated public officer presides in districts with the master's office, S39.2. In other districts, meetings follow the master's instructions and are presided over by a magistrate or designated officer, S39.2. Magistrate's absence must be explained if another officer presides, S39.4. Knowledge acquired by the presiding officer is imputed to the master, Wilkins v. Potgieter No 1996, 4, SA 936, T. Presiding officers who are not judicial officers cannot commit non-cooperative witnesses to prison, Delang v. Smuts No 1998, 3, SA 785, CC. 3. Record of proceedings. Presiding officer must keep and certify a record of the meeting, transmitting it to the master, S39.3. Minutes serve as prima facie evidence but can be contested, Pine Village Homeowners Association v. the Master 2001, 2, SA 576, SE. Unless proven otherwise, meetings are presumed to be validly convened, S68.2. 4. Privilege of statements. Statements made at meetings have the same legal privilege as court statements, S39.6. Next page. Chapter 9, Meetings of Creditors and Proof of Claims. _ 9.1 Meetings of Creditors. Meetings of creditors provide a forum for establishing claims, electing a trustee, giving directions on estate winding up. Creditors in this context are those with debts incurred before sequestration. Post-sequestration creditors, for example, attorneys providing services, do not need to prove claims. Krankel v. Borost's Trustee 1924 TPD 600 and 45 648, 4 types of meetings. First meeting, second meeting, special meeting, general meeting. Only first and second meetings are commonly held. Formalities can be waived by creditors. Leidsno v. Simon and others 1964, 1, SA 377, T. Resolutions taken at informal meetings are valid if irregularities are condoned. _ 9.1.1 First meeting. Convened by the master upon final sequestration order, S41, purpose. Proving claims. Electing a trustee. Notice requirements. Published in the Gazette at least 10 days before the meeting, S42, must specify time and place. S39.1, the master may alter the details with sufficient notice in the Gazette. _ 9.1.2 Second meeting. Convened by the trustee after the first meeting, S43A, purpose. Proving claims. Receiving trustees' report on their estate. See 11.7, Giving trustee directions on estate administration. Notice requirements. Published in the Gazette and a newspaper in the Insolvency District, S43B, must be in both English and Afrikaans, unless no newspaper exists in both, S43C, no specific time frame for publication before the meeting. _ 9.1.3 Special Meeting may be convened for I. Proof of claims. After the second meeting, a trustee may call a special meeting for additional claims, if requested by an interested party who covers expenses, S42(1), improper use solely, for interrogating the insolvent, Marks and another V. de Villiers and another NNO 1994, SA 415, W2, interrogation of the insolvent. Requires master's consent. Trustee must convene if requested by a proven creditor, S42(2), cannot be called only to interrogate other persons, Bernard v. Klein No 1992, SA 306, W. 308, _ 9.1.4 General Meeting. Convened by the trustee to obtain directions on estate administration, S41, must be held if requested by the master. Creditors holding 1/4 of proven claims. Includes meetings to consider an offer of composition, Mia v. the Master and others 1940 TPD 86, Illich v. Paginos 1985, 1 SA 795, A. 803, Notice Requirements, same as second meeting, S41, cannot be called only for witness interrogation, but may include interrogation if properly convened, Aesop v. the Master and another 1983, 1, SA 926, C _ 9.1.5 General Provisions on Meetings. I. Date and venue. The master sets the date of the first meeting, the trustee determines subsequent meetings. Presiding officer may adjourn meetings, S39(5), meetings must be held in a public place, S39(6). 2. Presiding officer. Master or designated officer presides in districts with the master's office, S39(2). Magistrate or designated officer presides in other districts, S39(2). If an officer other than the magistrate presides, they must record the reason, S39(4). Any knowledge gained by the officer is imputed to the master, Wilkins v. Potgieter No., and another 1996, 4, SA 936, T. 939. A non-judicial officer cannot imprison a recalcitrant witness, De Lang v. Smuts No. and others 1998, 3, SA 785, CC. 3. Record of proceedings. Presiding officer must keep a record, certify it, send it to the master, S39(3). Minutes are prima facie evidence but not conclusive. Pine Village Home Owners Association Limited and others v. the Master and others 2001, 2, SA 576, SE 580. Meetings are presumed valid unless proven otherwise, S68(2). 4. Privileged statements. Statements made at meetings have the same privilege as those in court, S39(6). _ 9.2 Proof of claims. 9.2.1 Necessity for proof of claims. A creditor must prove their claim at a creditor's meeting to share in estate distribution, vote on estate administration, challenge trustee actions. Proof of claim provides locus standi, serves as prima facie evidence of debt, proof in finance company, proprietary, Limited v. Cohen and others NNO 1991, 2, SA 345, W 348, exceptions. Employees do not need to prove their preferred claims for salary/wages, C16, 3(2)V, registration without proof. A creditor may register their name for R25, S43, entitled to notices of meetings, accounts, and sales. Failure to comply does not invalidate proceedings. Solvent spouses creditors. Must prove claims against insolvent estate to share insolvent spouse's assets, S21-5, not entitled to. Separate assets of insolvent spouse. Contributions under S106. Voting rights in the insolvent estates meetings, S21-9, _ 9. 2 time for proof of claims. Claims can be proved at any time before final distribution, S44-1, after 3 months from the second meeting closure, proof requires leave from master or court. Payment of costs, S44-1, the 3-month rule applies to sequestrations and liquidations, Wishat No and others VBHP, Billiton Energy Coal South Africa, Proprietary, Limited and others 2017, 4, SA 152, SCA, a creditor may delay proof to avoid contribution liability, Coulsby the Master and others 1998, 4, SA 212, C, late proof after plan submission. Cannot share in distribution unless the master allows, S104-1, if excluded, may receive an equalizing dividend in a later plan, S104-2, exclusion from recovered assets. A creditor delaying proof due to pending legal proceedings to set aside a disposition cannot share in the recovered proceeds, S104-2, _. Next. Page 9.2 Proof of claims. 9.2.1 Necessity for proof of claims. A creditor must prove a claim at a meeting of creditors, first, second, special, or general, 2. Share in asset distribution. Vote on estate administration matters. Challenge trustees' actions. Establish prima facie proof of debt existence, Gruffin Finance Company, Proprietary, Limited v. Cohen and others NNO 1991, 2, SA 345, W, 348. Exceptions. Certain creditors, for example, employees with preferred claims for wages, are exempt from proving claims in the ordinary way, C16, 32v. Non-proving creditors may register their details for a 25 under S43, entitling them to receive notices of creditor meetings, copies of trustee accounts, notices of property sales over which they hold a preferred right, for example, mortgage, pledge, retention right, landlord's hypothec. Failure of the trustee to send notices does not invalidate actions under the Act, S43. Creditors of a solvent spouse's estate can only claim against that spouse's assets if they prove a claim against the insolvent estate, S21-5. Such creditors cannot share in separate assets of the insolvent estate, S21-5, are not liable for contributions under S106, S21-9. Cannot vote at meetings of creditors of the insolvent estate, S21-9. 9. 2 time for proof of claims. Claims may be proved any time before final distribution of the estate, S44-1. After 3 months from the closure of the second meeting, late claims require master's or court's leave. Payment of an amount directed by the master or court for costs, S44-1. The 3-month period applies to both sequestrations and liquidations, Wishat No and others VBHP Billiton Energy Coal South Africa, Proprietary, Limited and others 2017, 4, SA 152, SCA. In Coulsby the Master and others 1998, 4, SA 212, C. The court held. The master must allow late proof even if the delay was due to a creditor fearing contributions. Presman A.J., Edom 222. A creditor may legitimately delay proving a claim to avoid risk of contribution. If a creditor proves a claim after the trustee submits a plan of distribution, they cannot share in the proceeds unless the master allows it before confirmation, S104-1. If the master rejects the claim, the creditor can receive an equalizing dividend in a later distribution, S104-2. If a creditor delays proving a claim while awaiting judgment, in proceedings to set aside a disposition, they cannot share in the recovered proceeds, S104-2. Next. Page 9. 2-3 Procedure for Proof of Claims. General Procedure, S44, applies to both liquidated and unliquidated claims despite reference to liquidated claims in S44-1, Cashelier v. de Klerk No. and Benjamin, No. 1952, 4, SA 672, T. 678, Illich v. Parginos 1985, 1, SA 795, A. 803. Exception, creditors realizing security under a master agreement, S35b2, are subject to S8310AA as amended by Financial Matters Amendment Act 18 of 2019, Financial Sector Laws Amendment Act 23 of 2021. I. Documents required for proof of claims. A claim must be proved by affidavit, Form C or D in First Schedule, S44-4. Form C. General Claims. Form D. Claims based on a bill of exchange. Affidavit requirements. Basis of the deponent's knowledge of the claim. Nature and particulars of the claim. Whether the claim was acquired by cession after sequestration proceedings began. Security details if applicable. If security not realized, creditor must state valuation, S44-4. If security realized, creditor must annex a statement of proceeds and preference basis, S83-5. Formal clarity and precision required, Rousseau and Rousseau v. Hodgson, and others 1925 AD 97-99 104. If claim is based on multiple grounds, each must be clearly stated, Marandas v. Smuts 1966, 4, SA 66, T. If claim involves goods sold on an open account, affidavit must include monthly totals, brief descriptions of purchases/payments, covering the lesser of 12 months before sequestration, or the full trading period, S44-6. Claims based on documents. For example, acknowledgement of debt, mortgage bond, must include original/copy, Taylor and Thorne NNO and others v. the Master 1965, 1, SA 658, N2 Time and place for lodging claim documents. Deadline. Affidavit and supporting vouchers must be delivered at least 24 hours before the meeting, S44-4. Failure to meet the deadline. Claim cannot be admitted, unless the presiding officer finds the delay was not due to creditor's fault. Mandatory rule, court cannot override, Derby Shirt Manufacturers, Proprietary, Limited v. Null No, and another No 1964, 2, SA 599, D. Errors or omissions. If documents lack required information, the presiding officer may allow a postponement for proper submission, Sherman v. the Master and Paxton No 19, 25 TPD 188. 3. Examination of claim documents. Who can inspect claims? Creditors, trustee, insolvent or their representatives. Access, free inspection during office hours, S44-5. 4. Attendance by creditor. Not mandatory to attend the meeting. If claim documents are lodged on time, creditor is deemed to have tendered proof at the meeting, S44-3. Attendance recommended if objections arise. V. Interrogation of creditor. Presiding officer's authority. Can interrogate anyone proving a claim under oath, S44-7. Who may conduct interrogation? Presiding officer. Trustee. Any creditor, or their agent, who has proved a claim, S44-7. Summoning absent claimants. If creditor is absent, they may be summoned to appear for interrogation, S44-8. Failure to comply. If the creditor refuses interrogation or fails to appear without reasonable excuse, their claim may be rejected by the presiding officer, S44-9. Expunged by the master if already proved, S44-9. Presiding officer cannot expunge claims unless they are the master. Abuse of interrogation process. A meeting cannot be convened solely for interrogation after a claim has been proved. Eastern Cape Development Corporation v. Master of the High Court, Port Elizabeth 2017, JDR 0577, ECP, Para 23. Next page. Adjudication and review of claims in insolvency law. Vi. Adjudication on claims by the presiding officer. Claims must be proved to the satisfaction of the presiding officer, who must admit or reject them. S44.3. The presiding officer performs a quasi-judicial function and must exercise independent judgment. Air-Condi Refrigeration, Proprietary, Limited v. Ruskin Knoll and others 1981. 1. SA 799, W. 804. The claim must be scrutinized closely, but without rejecting it on technical defects. Asperling and another v. Hoffman's Trustee 1917 TPD 305, Hassim Wati and Co. v. Insolvent Estate, M. Jusub, and Co. 1927 TPD 778. A claim should be rejected if it is bad on its face, such as being prescribed. Asperling and another v. Hoffman's Trustee Supra. If prima facie proof is provided, the claim should be admitted. Ilsley v. de Klerk No, and another 1934 TPD 55. The presiding officer must allow the creditor to present further evidence before rejecting a claim. S44.7. Umbane Technology CC v. the Master of the High Court SA Pretoria Division, 2021, JDR 0697, GP. The presiding officer cannot call for evidence beyond that of the creditor. Peach v. Stewart No and another 1929 WLD 228. Rejection does not prevent the creditor from proving the claim later, or enforcing it through legal action. S44.3. 7. Trustees set-off of claims. Set-off occurs when two parties are mutually indebted, and both debts are liquidated and fully due. Shahout v. Union Government, Minister of Justice, 1926 AD 286-289. S46 governs set-off in insolvency, preventing unfair advantages to creditors who received set-off before sequestration. If a party's estate is sequestrated within 6 months after set-off, the trustee can abide by the set-off or disregard the set-off, if it was not in the ordinary course of business and the master approves. If set-off is disregarded, the debtor must repay the full amount to the estate and prove their claims separately. The set-off is binding where it involves a market participant under S35A, or an agreement under S35B. MGG Productions, Proprietary, Limited v. Ramadike Knoll and others 2021, 4, SA 543, GJ raised constitutional concerns regarding property deprivation, under S25 of the Constitution. Contextual analysis is used to determine whether set-off was in the ordinary course of business. Relevant factors: uniqueness or unusual nature of the transaction, disruption to asset distribution, existence of similar transactions, extraordinary size of the transaction, disputed debt, roundabout payment method, consideration for the reciprocal debt. Set-off differs from voidable dispositions under S29, as it is an operation of law and not a disposition in Re Trans African Insurance Company Limited, in liquidation, 1958, 4, SA 324, W. 329. 8. Trustees' examination of admitted claims. Admission of a claim is provisional, and the trustee can still dispute it. Cashelier v. de Klerk No and Benjamin No 1952, 4, SA 672, T. 675. Trustee must examine all estate records to verify the claim. S45-2, Braga No v. Master of the High Court, Kimberley 2015, JDR 2590, SCA, Para 23. Trustee must rely on books, documents, and relevant evidence, such as the insolvent statements. Standard Bank of SA, v. the Master of the High Court 2010, 4, SA 405, SCA 426. Trustee must reasonably believe the estate is not indebted before disputing a claim. Caldera v. the Master and another 1996, 1, SA 868, N. 874. Standard Bank of SA, v. the Master of the High Court 2009, 5, SA 13, E. 27. If the claim may be prescribed, the creditor must prove that prescription was delayed, or interrupted. Breda Novi Master of the High Court, Kimberley, Supra. If disputing the claim, the trustee must report the dispute to the master with reasons, S45(3). Notify the claimant and provide 14 days to respond, or longer if the master allows, Reg 3(1). The master may confirm, reduce, or disallow the claim, S45(3). The claim is not automatically expunged at the trustee's request. The master must consider the reasons, Caldera v. the Master and another, Supra, 874. If a claim is per fair, the trustee can address it in the liquidation account instead of disputing it under S45(3). Kalinikos v. Berman 1963, 1, SA 489, A, 500. Reduction/disallowance does not prevent enforcement through legal action, S45(3). PG Bison Limited v. Johannesburg Glassworks, Proprietary, Limited, in liquidation, and others 2006, 4, SA 535, W, 9, action to establish a disputed claim. A rejected or disallowed claim can be enforced through action against the trustee, the Master v. Stewart 1981, 2, SA 472, E. S75(2). No action may be brought after the master confirms the trustee's account unless a reasonable excuse for delay exists. If the account is not final, action can still be taken. Wilkins v. Potgieter No. and another 1996, 4, SA 936, T. 941. S44(3) allows legal action regardless of claim rejection. A claim need not be rejected first to enforce it. Barlow's Tractor Company, Proprietary, Limited v. Townsend 1996, 2, SA 869, A, 879. The trustee, with creditor or master's authorization, may compromise or admit a disputed claim to avoid litigation, S78(3), Standard Bank of SA Limited v. Cato, and Gunn NNO and others 1981, 1, SA 647, W. A compromised, admitted, or judicially settled claim is deemed proved and admitted, S78(3), though an appeal may still be pursued. Cashelier v. de Klerk No. and Benjamin No. 1952, 4, SA 672, TX. Review of decision on proof of claim. Any aggrieved party, creditor, trustee, or insolvent, may apply to court for review, S151, Millman and another NNOV Peterser, and others 1997, 1, SA 784, C. A person is aggrieved if their rights or interests are harmed, Jiva and another v. Tuck No. and others 1998, 1, SA 785, SE 792. Review cannot be sought for indirect effects of the decision, Jiva case. Court has wide discretion to reconsider claims de novo, including fresh evidence. Talaki and another v. the Master and others 1997, 1, SA 702, T. 706, De Jager v. Harris No. and the Master 1957, 1 SA 171, SWA 174. Judicial Review under Promotion of Administrative Justice Act 3 of 2000, PAJ, applies, allowing review for irrationality or procedural unfairness. Steelnet, Zimbabwe, Limited v. the Master of the High Court Johannesburg 2008, JDR 0767, W. Next. Page 9, 2.4 Arrear interest. A creditor may claim arrear interest up to the date of sequestration if it was payable by agreement or it arose due to the insolvent's default in Mora, S51. Secured creditor. Secured claim, interest for up to 2 years, S89(3). Concurrent claim, interest exceeding 2 years. 9, 2.5 Conditional debts. A creditor with a conditional claim may prove it normally, S48. If the condition will be fulfilled within 1 year, dividend held by the master and paid only if the condition is met, S48A. Uncertain or will not be fulfilled within a year, trustee must place a value on the claim at a creditor's meeting, S48B. Condition fulfilled before trustee's account confirmation, creditor can prove the claim as unconditional, IBID. Court rulings on conditional claims. Unliquidated conditional claims do not fall under S48 and must wait for fulfillment. Proch v. Die Meester en Ander 1969, 4, SA 567, A. A surety's claim where the main creditor has already proven their claim is unliquidated. Absa Bank Limited v. Sharigwizan 2000, 2, SA 998, C. 1006. Subordination agreements. A subordinated creditor has no claim in insolvency before sequestration claim exists, but is unenforceable until conditions met. After sequestration claim is extinguished, ex parte de Villiers and another NNO. In Recarbon Developments, Proprietary, Limited in Liquidation, 1993, 1, SA 493, A, 504-5. 9. 2.6 Debts payable after sequestration. Distinction. Conditional debts may never become payable. Debts payable after sequestration are certain but due later. Creditor rights may prove the full amount of the debt as if payable on sequestration, S52. If the debt bears interest, creditor can claim interest until the due date, not just sequestration. Trans Drakensberg Bank Limited v. The Master and Others 1962, 4, SA 417, N. Abatement of non-interest-bearing debts. If a distribution account is confirmed before the due date, the trustee must reduce the claim by 8% per year, S52. This applies to installment debts, Bassa v. The Master and Another 1963, 4, SA 510, N_. 9.3 Voting and resolutions of creditors. Creditors direct the trustee via resolutions at meetings. Purpose: to facilitate efficient asset liquidation. Jordan v. Richter and Ander 1981, 1, SA 490, 0496. 9.3.1 Entitlement to vote. General rule: any creditor with a proven claim may vote, S52(1). Exceptions: cession of claims post-sequestration, no voting right, S52(4). Ruskin No v. Speedy Engineering Works, Proprietary, Limited and Others 1975, 4, SA 126, W. Secured creditors can vote fully on trustee election and matters affecting security. Limited voting power on other matters, S52(5), Brittle v. The Master and Others 1980, 1, SA 468, 0. Cannot vote on disputes regarding their own claim, S52(6). Conditional creditors. No voting right if the condition will be fulfilled within a year, S48A. If the claim is valued under S48B, they may vote on that value. 9.3.2 Determination of vote. General rule: voting power is based on claim value, S52(2). Majority required: most votes cast by value, S53(2). Special cases: election of trustee and composition offers votes counted by value and number, SS 54-4, 119-7. Claims under R1, OO are excluded from number-based votes, S52-3. 9.3.3 Questions on which creditors may vote. Can vote on estate administration matters. Cannot vote on asset distribution except to contest, compromise, or admit claims, S53-1. 9.3.4 Voting through an agent. A creditor may vote via an agent with general power of attorney or special authority, S53-2. Telegram authorization was deemed valid. Caledon Trust and Fire Assurance Company Limited, Magistrate of Riversdale, and Others 1937 CPD 349. Prohibited voters, S53-2A, E. The trustee. Trustee's employer/employee. Trustee's spouse or close relative. Co-employee of the same employer. Anyone with a financial interest in the trustee's remuneration. 9.3.5 Resolutions of creditors. Minutes must record all resolutions and voting outcomes, S53-3. Binding effects. Resolutions directing the trustee are binding, IBID. A resolution binds all creditors, even those absent or voting against it. Trustees of the insolvent estate of S. W. Sutton v. H. and T. McCubbin, 1891, 12 NLR 351, Slater's Trustee v. Smith and Co., 1886, 4 SC 135. A creditor can withdraw their claim, within 5 days of a resolution, to avoid its effect, S. 106b. 9.3.6 Setting aside creditors' resolutions. A court may set aside a resolution if taken irregularly, beyond creditor's competence. Jordan v. Richter N. Ander 1981, 1, SA 490, not in good faith, i.e. aimed at fraud or an ulterior motive. Peruke and others v. Parker, Wood & Co. Limited 1917 AD 163-168, Jansa van Rensburg v. Muller 1996, 2, SA 557, A. 564. Protection of creditors' rights. The court may invalidate any direction that infringes a creditor's rights. Action may be brought by the affected creditor, the trustee, with the master's consent, S. 53-4. A person who has not proved a claim, but is prima facie a creditor has standing to seek relief. Pine Village Home Owners Association Limited and others v. The Master and others 2001, 2, SA 576, SE 581.